Dear colleagues, can I please ask everyone to take their seats? It's very good to see you all gathered again in this Hall of Knights. The family photo, which was taken before lunch, will be handed out to you when you leave this venue at the end of this afternoon. I would like now everyone to take their seat. Dear colleagues, this morning I briefly mentioned the terrible attack of yesterday in Orlando, in which at least 50 people died and another 50 were wounded. Our thoughts are with the victims, their families, friends, loved ones, and I would now like to ask you all to rise and to be silent for 1 minute out of respect for the victims and their families. Thank you very much. Before we move on to the second session, I would like to inform you that we have received 8 amendments to the final draft contributions. The amendments, an updated table, and the document final draft contributions will be sent shortly via email to all delegations, uploaded onto our website and in the app, and it will also be distributed on paper in this hall. We now move on to the second session, which focuses on the Parliament's involvement in protecting the rule of law. And this session will be moderated by Mr. Murray Hunt, who is a visiting professor at the Oxford University. Mr. Hunt, the floor is yours.
Thank you very much indeed, Mr. Elsegar, and thank you to COSAC and to the Dutch presidency for the invitation to me today to act as the moderator of this panel, for which I'm very grateful. I'm also, as my day job, the legal advisor to the Joint Committee on Human Rights of the UK Parliament, a job I've been doing for the last 12 years. So I'm not a parliamentarian. In fact, the biggest democratic mandate I've ever enjoyed was as a school governor at my children's primary school, a post for which I was elected unopposed, so it doesn't really count very much either. But unlike you, I therefore don't have the democratic mandate that most of you have. But I have worked for many years with parliamentarians in my capacity as legal advisor to the Joint Committee on Human Rights. And as a result of that long period of working, I have a profound respect for the work that parliamentarians do, and I hope a deep understanding of the pressures that they work under. I also lead a research project at the University of Oxford, which is called the Parliament's The Rule of Law and Human Rights Project. And that project tries to stimulate research internationally on how parliaments can go about increasing their role in relation to rule of law and human rights. And that's the work that I've been engaged in the last several years in the UK Parliament, trying to bring into the heart of the political process in the United Kingdom considerations of the rule of law and human rights. And I'm a passionate believer, personally, in the urgent need to increase the role of parliaments, both in relation to the rule of law and human rights. And that's how it is that today you have standing before you an unelected legal advisor to talk to you on this very important question of what Parliament's role is and should be in protecting the rule of law in the European Union. Next Wednesday, the 22nd of June, I shall be taking part in another panel discussion, this time in Geneva, in the UN Human Rights Council. And that panel discussion is on the topic of the contribution of parliaments to the work of the Human Rights Council. And the purpose of that panel discussion is to take stock of the work that parliaments have been doing in relation to human rights in the UN human rights system, and also to look forward to see what opportunities there are in future to enhance that work. And I mention this to you because I think it's significant that today's panel discussion and next week's panel discussion in the UN Human Rights Council is evidence, they are evidence of a significant international development of recent years. And this is happening all over the world. It's happening in many international organizations. It's happening in the Commonwealth. It's happening in the Council of Europe. It's happening throughout many regions of the world, the Asia Pacific and Africa. There is a growing realization of the importance of getting parliaments and parliamentarians more involved in discussions and debates about human rights. And what's emerging is a clear consensus about what we understand today in the 21st century by the rule of law. And it's quite a broad, substantive concept of the rule of law that we're now all working with internationally. It isn't confined to purely formal considerations of legal certainty and lack of arbitrariness, important as those are, but it also extends to more substantive questions concerning access to justice, equality, non-discrimination, and human rights. But even more significantly, in my view, there's an emerging consensus also that there's now a shared responsibility between all the branches of the state, as well as the judiciary. Governments and parliaments also have a responsibility to uphold and protect and take positive steps to realize the rule of law, including human rights. So we have this significant emerging international consensus. But, and it's a very big qualification, at the same time, we have a heightened and I think growing concern about the democratic deficit of our institutional arrangements for protecting the rule of law and human rights. Now, I know many of you may perhaps roll your eyes to hear someone from the UK talking about democratic deficits today. But it is undoubtedly the case that worldwide there is heightening concern about democratic deficits. And it's something which we should all be extremely concerned about. In my view, it's the greatest challenge, the legitimacy challenge. Of course, courts are extremely important in upholding and protecting the rule of law, and we mustn't belittle their role. But parliaments are absolutely central to upholding and protecting the rule of law, including human rights. And this heightened concern about a democratic deficit suggests that there is still a great deal to do in terms of our institutional mechanisms and structures, our processes in our parliaments, our systems, all the things we can put in place to enhance Parliament's role. So it's an extremely timely session, this session we're having this afternoon, and it's an urgent question to ask: what exactly is the role of parliaments in relation to the rule of law? And that's what we're really going to focus on in this session. How do parliaments do it? How have they been doing it? And could they do it better? And I would like our discussion really to be structured around three main themes. And I think they will be displayed on the board behind me, because this will really be the three main questions that I would like our conversation this afternoon to focus on. The first question is the why question, the normative question. Why should parliaments have a role in protecting and realising the rule of law? Why does it matter? Why can't we leave it all to courts to look after the rule of law? We want to talk about questions of effectiveness. Are parliaments effective? How can they be more effective? Is that the main reason? Are there even more important legitimacy considerations which justify a greater role for parliaments? The second question I'd like to concentrate on is, what have parliaments done so far to assert such a role in relation to the rule of law and human rights? And here I'm extremely grateful for the draft biannual reports, the biannual report of COSAC, which you will all have seen now, the chapter concerning the rule of law, which has conducted an extremely interesting survey of the parliaments of the member states. And it's asked a lot of the right questions, in my view, and it's made some very interesting findings as well, in my view. And I'd like our discussion to take account of those findings in the returns to that questionnaire and the very good analysis contained in Chapter 2 of the COSAC report. Very briefly, I think that report finds a lot of interesting practices going on, but for me the headline is how much more work there is to do and how much more could be done to build on those practices which are already established in many parliaments. In relation to drafting legislation, for example, we see from the report that most parliaments take the rule of law seriously and see their role in drafting legislation as being to make sure that the standards of the rule of law are complied with in the legislation that is drafted. But how systematic is that in most parliaments? And are there lots more things that could be done to systematise that consideration of standards to comply with the rule of law? The report also finds that holding Parliament's own governments to account on rule of law and human rights standards is done by some parliaments, but perhaps not by all parliaments. And again, there's probably quite a lot of work that could be done there in fulfilling the Parliament's role of holding the government to account. On structures, we see that there are many committees in many parliaments which have a function in relation to the rule of law and human rights. And some of those committees provide some very interesting examples of best practice. But again, what of those parliaments where there are no such structures which yet exist? And an interesting question, where those structures do exist, is there a problem that the rest of Parliament leaves it to those committees to deal with rule of law and human rights questions? Is having a specialised committee a disincentive to mainstreaming human rights across everything that a Parliament does? We see from the returns also in the analysis that ratifying human rights treaties is an important role that Parliaments often fulfil, considering rule of law concerns. But again, how much more could be done? How much more debate could there be in the plenaries of our parliaments about whether human rights treaties should be ratified, and how much involvement is there at the earlier stage when human rights treaties are being negotiated? We see that there are often debates in our parliaments on human rights, but again, how often do they take place? Are all the opportunities to have such debates being taken in our parliaments? And what is the quality of those debates? Could the quality somehow be made better? We also see that most parliaments have access to some form of support, the back office, as somebody mentioned it this morning, a research and information service, legal advice. But again, are those up to the job? Could they be improved? Could they be improved even without much significant more resource, by being better organised? Could they be more proactive to help parliamentarians to identify rule of law and human rights issues? We also see in that chapter of the COSAC report references to international bodies and mechanisms are infrequent in parliaments. Participation, yes, parliamentarians are very good at participating in interparliamentary mechanisms, but the follow-up in the national parliament is sadly quite lacking in most parliaments. There is very little reference in parliaments to the work that parliamentarians do in those interparliamentary bodies. So I've picked these out as some examples. There are many other examples in the chapter which really repays careful reading. And the third question I want to focus on in our discussion is forward-looking. How in the future can parliaments increase their role in relation to the rule of law in human rights? Can we go beyond identifying and sharing best practice? That's extremely important. But can we go beyond merely sharing best practices? Can we deepen and enrich parliamentary debate about human rights and the rule of law? Can we mainstream the rule of law across everything that Parliament does, rather than leave it to be dealt with in the particular silos of individual specialised committees? Can we make more use of interparliamentary dialogue in these sorts of fora? And can we explore what scope there might be for international agreement about guidance to help parliaments, both at the international level and at more regional levels, or at the level of parliaments who have same things in common? We could have lots of different layers of guidance to parliaments to assist them to fulfil this important role. Well, I'd like to move now from those introductory comments, if I may, to introduce our panel. We're very fortunate today to have two extremely distinguished panel members, and if I could ask them as I introduce them just to come up and take a seat on the stage, please. First of all, Mr. Peter van Dijk, an extremely distinguished human rights expert, a former member of the Venice Commission, and recently involved in drawing up the rule of law checklist of the Venice Commission, with which many of you, I hope, will be familiar. And secondly, Ms. Sophie 't Veld, who is a member of the European Parliament and a member of the European Parliament's Human Rights and Civil Liberties Committee, and rapporteur currently of a report concerning the establishment of an EU mechanism on democracy, the rule of law, and fundamental rights. Now, we're going to have a panel discussion of about 20 minutes, in which I will ask some questions of Sophie and Peter, and we will then open it up to, I hope, 40 minutes or so of discussion with contributions from the floor. Sophie and Peter, welcome. Can I just start by asking you both, the rule of law, it's a very academic sounding concept, and often in my parliament, when I start talking about the rule of law, a lot of eyes start to roll, apart from the lawyers around the table, who then enter into a sort of almost secret discussion with me as a lawyer. Can we turn the rule of law into a practical, usable concept by politicians who may not be lawyers? Peter, can I ask you to start?
Well, I'm always surprised how often there are references to the rule of law, both in governmental and non-governmental circles. But of course, there is the risk that it will be and will remain a subject of lip services. Because we could say that there is more or less common consensus about the core principles, but that doesn't mean much, because the core principles are so basic that nobody could deny their value. But of course, what is important is the implementing principles. And there, even in the case law of the European Court of Human Rights, you do not find a development of those principles. So for the implementation of the rule of law concept, it is very important that we also agree about the main principles. They don't have to be uniformly applied in all circumstances and in all countries, but at least there should be some common sense about what are those rules, those implementing rules. And I'm very pleased that today I have the opportunity on behalf of the Venice Commission to introduce, in the presence of so many parliamentarians, our effort to draw guidelines on those implementing principles. And so you will find them in the checklist, and I hope that the checklist could be a useful tool to reach more consensus about these principles and rules, and that they can contribute to the implementation of the concept.
Before I ask Sophie, could I just ask you to explain how you see parliamentarians making use of the Venice checklist?
Well, of course, I refer to the European Court of Human Rights, and it is clear that it is one of the main tasks of the European Court to review the implementation of the rule of law and to enforce it. But as we all know, the primary responsibility for the implementation of the rule of law and human rights rests with the states. And in the states rests with all the organs of the state, not only the executive, not only the judiciary, but also parliament. And I hope that the checklist can help national parliaments, the European Parliament and the Parliamentary Assembly to find common grounds to review the practice of the states and to also review the practice of international organizations with respect to the implementation of the rule of law.
Thank you very much, Peter. Sophie, can I ask you to say anything at all you want on that question, but also to ask you, you have talked about the EU as a community of values, including the rule of law as one of the most important values. Could you just explain that, what you mean by that a little, and what sources you think should inform discussions about that?
Yes. Well, thank you first of all for having the opportunity to have an exchange of views with my fellow legislators and parliamentarians. I always say when you talk about shared values, they are essentially the values that are laid down in Article 2 of the treaties. I think that it's for a reason that is actually the most important article. Article 1 of the treaty says basically, hello everybody, and then Article 2 is about our shared values. And we all agree that the European Union is based on the principles of democracy, the rule of law and fundamental rights. But then what does that mean in practice? And up till recently, I think those concepts were applied mainly in a national context, but now increasingly we are moving into policy areas where it becomes extremely important that we also apply those principles at European or indeed global level, but then we have to agree on what those principles are, but also how do we put them into practice. And that is the process that we are embarking upon now. We have taken the initiative in the European Parliament, but it's clearly the idea that we're going to make this a common exercise with all elected representatives in national and the European Parliament. And in response to your first question, how are we, what does it mean for us? Well, we are all, on the one hand, legislators. We pass laws. So we have to make sure that the laws that we pass are, they meet the standards of democracy, the rule of law and fundamental rights. And on the other side, we also exercise democratic oversight, parliamentary oversight. So we also have to make sure that the executive applies the same standards. So in both roles, I think we are confronted with these concepts.
Okay, thank you both very much indeed. Can I ask about the why question, why this matters so much, and in particular your thoughts about effectiveness and legitimacy as being the two big considerations. How can parliaments be more effective in what they do if they're properly advised about rule of law and human rights? And also, how does it give rise to more effective protection of rule of law and human rights? Peter.
Well, in general, I think in the legislative field, the proposals are drafted by government. There may be parliamentary initiatives, but usually drafted by government. So the first responsibility lies on the government to make sure that proposed legislation is in conformity with the principles and rules of the rule of law. But of course, Parliament is the legislator, and so Parliament has to check to what extent the government has done this job in the right way. And so it is very important that in the preparation and in the discussion of draft legislation, Parliament uses the benchmarks of the rule of law as guidelines. Not only those, of course, there are many other things like effectiveness and so, but to use them as guidelines for the quality of the law. That's the one part. The second part is, of course, that Parliament has a common responsibility for the legal culture in the country. So it shares that with the other branches of the state. And in that way also it is very important that Parliament, apart from concrete legislation, has periodical discussions about the state of the rule of law in their country and as we said in the international organizations concerned.
Okay, thank you. Sophie?
Yeah, for us in the European Parliament, it's actually very, we're confronted with very concrete, practical challenges. And I think having a common framework for the rule of law is essential to make the European Union function. A couple of examples. If, for example, member states do not trust each other's judicial systems, then, as we have seen in practice, the European arrest warrant doesn't work, because then extradition from one EU country to another is not allowed by the judges. This is actually happening today. And when we say we're making a common effort to fight terrorism and crime, then this is key. So trust in each other's judicial systems and the fact that everybody is applying the same standards is essential. But also for more mundane things like the internal market or trade. Earlier I spoke to someone and I gave the example of ISDS, this very controversial dispute settlement system in TTIP. That is actually the expression of distrust between the European member states. We don't trust each other's judicial systems well enough, and that makes us weak in the negotiations with third countries. So, but also when you think about a common asylum and immigration system, there's so many policy areas where if we don't work on the basis of common standards, and that does not mean a uniform system, that's clearly not what it means, but if we don't have a kind of, well, mutual recognition, if you want, common standards, then the European Union will grind to a halt. And we actually see that happening in some policy areas.
Thank you. And can I just press you both a bit on the idea of democratic legitimacy? In the UK Parliament, it is a very tangible fact that many members, particularly of the lower house, the House of Commons, very sincerely feel that they are marginalised in discussions and debates about rule of law and human rights. And so I'm very interested in how we can help elected politicians to take ownership of the content of the standards in all those international standards about rule of law and human rights. So perhaps could you say something about that?
Well, in particular, I can only speak about the European context because that's my, my business. But what I note in practice is that these topics of democracy, rule of law and fundamental rights are still very sensitive. Very often member states say, hey, this is national business, leave us alone, we'll sort it out. But what happens then in practice is that we basically shift the decision to the courts. And that actually means that we put policy-making powers in the hands of the courts. And therefore it's very important what you're saying, that you know, we parliamentarians, we take back not only that power, but also that responsibility. And of course there's always a kind of tension between democracy and the rule of law. Because if, for example, courts rule on something which goes against a democratically elected majority, then there is a certain tension. At the same time, I think we all acknowledge that a part of the rule of law is that there is a certain legal framework that cannot be easily changed, you know, just because majorities change overnight, that there is a certain basic framework. And that is something that we need to agree on amongst ourselves at European level too.
Yes, thank you. Peter, did you want to add?
Well, as we said, it is a shared responsibility, so the judiciary, although not democratically elected, of course, has also a mandate to protect the rule of law, but always under the proviso that it is acting in conformity with the law drafted by a democratically elected legislature. The relationship between democracy and the rule of law is a very interesting one, but it is also important for Parliament internally. Because, as you said, some members of Parliament have less, or may feel that they have less opportunities to defend the rule of law and to speak out than others, and that is because sometimes a parliament is ruled by a majority and the minority is not always fully respected. Therefore it is so important to say the rule of law has as one of the pillars real democracy, and real democracy means of course that you also respect the minority and that you give equal opportunity to all the elected members of parliament.
Yes, indeed. And there's a great deal that parliaments can do to take their own role seriously and to have these debates without necessarily having to criticise courts. That there's an enormous amount of scope for parliamentarians to just become more involved. Yeah. And if they do become more involved, courts, we would expect in a democracy, should respond in kind if they've done a good job of their democratic deliberation. And I think there's an interesting turn in the Strasbourg case law towards in this idea of subsidiarity, that the Strasbourg court is subsidiary to the domestic human rights system. So to the extent that the domestic human rights system hasn't protected human rights adequately, Strasbourg has a legitimate role. But that first stage means that the Strasbourg court must take national parliaments very seriously in terms of what they do, without surrendering their supervisory role.
Yes, I would like to just make one footnote to that. In the end, the courts protect the rights of the citizens and not necessarily the rights of governments or parliaments. Sometimes they actually have to protect citizens against governments. So subsidiarity in this case should actually mean, you know, the smallest level, the lowest level is the individual citizen.
Yeah.
Can I move on to the second of our questions, what parliaments already do? Would you be able to say which of the best practices that you're aware of across the EU states is the most important or the most significant? What practice would you say is the highest priority that parliaments should follow?
Well, it is very difficult for me to evaluate because I've seen the figures, of course, but I don't know what they stand for. It is very difficult, even for the parliament of my own country, to see what it actually means. A yearly report, what does it mean? It depends on the sources that you have used. Is there also an input from civil society? Is there an input from our Human Rights Committee? Is there an input from the Bar Association? That is, I see in the answers that there is, but I do not know to what extent.
Right.
But of course, I'm also impressed by the efforts, and they seem to be growing. I want to stress also one external aspect of putting your own house in order. If you think as a state and as a parliament of a state that you are also entitled to criticize other countries, members of the EU, members of the Council of Europe, for declining tendencies of the rule of law, then you have to make sure that your own house is in order, because otherwise you have no authority to signal that.
Sophie?
Yes, well, we are of course in a different position than national parliaments, and as I said earlier, we have embarked now on a process of setting up a framework or a mechanism, whatever you care to call it. I prefer to call it a pact on how we can uphold standards of democracy, the rule of law, and fundamental rights throughout Europe. And so this is, I think, the contribution that the European Parliament is making at this stage. But clearly, that is something we can only do in a joint exercise together with national parliaments. But for me, as I'm rapporteur for this report, and one key element will be an annual and public debate, a parliamentary debate, together with the national parliaments, and hopefully also within each of the national parliaments, about, you know, what are those standards? Because a couple of things, when you're talking about the rule of law, fundamental rights, they're pretty obvious. They are laid down in treaties and laws and what have you. But then they're always interpreted in the context of the time, just as judges, for example, interpret the law, and it's always the same law. But the way they interpret it may vary over time. You know, a judge today may rule differently in the case of, let's say, LGBT rights than he would do 20 years ago, even if the law is still the same. So it's very important that this is not, you know, a one-off decision. This is not static. This is something that needs to be defined in an ongoing public debate. And we hope that we are going to create the platform for that.
Peter.
Mr. Moderator, if you give me 1 minute to make some advertisement for the Venice Commission, because I'm no longer a member, so I think I'm allowed to do so. As you say, well, what is your impression about the state of the rule of law in the different member states? Then I was always astonished that the Parliamentary Assembly and the Monitoring Committee of the Parliamentary Assembly saw the necessity to put so many draft legislations of member states in front of the Venice Commission, and that usually the opinions of the Venice Commission were very critical about the extent to which the rule of law was taken into consideration by that particular parliament. And I must say that most of the parliaments were of Central and Eastern European countries, but that is because Western European parliaments refuse so far to put their draft legislation in front of the Venice Commission. And I would like to call upon parliaments to use that opportunity, because sometimes it can be very useful if you have doubts about the rule of law character of the draft legislation put before you by the government, whether that is in conformity with the rule of law, to ask an opinion of the Venice Commission.
If I may, because there was one element that to me is so self-evident that I even forgot to mention it, is as a European Parliament, of course, we are closely scrutinizing what the European Commission is doing, and very often also, let's say, sparring with the Commission, with the Council, sorry, with the Member States on the legality and the constitutionality of legislative proposals, but also on the execution. We scrutinize that as well. So at European level, we do exercise that role, not always to the content of the Commission and the Council, but I think if we annoy them, then we're probably doing a good job.
Thank you. Well, that brings me very nicely to the last set of questions before we open up to discussion contributions from the floor, which is looking to the future. I'm very keen that all of us can go away from this room today and think about how can we do it better in our national parliaments. Because one of the clear lessons is that we can all do it better, even in places where there are some quite good practices established already. So I'd like to ask you both, what do you think would be the most effective engine for mainstreaming the rule of law and human rights across everything that Parliament does? Is there any single factor or most important factor that would help parliaments to look at and consider the rule of law and human rights across the piece in everything it does?
Well, of course, I saw in the questionnaire questions about special committees in Parliament. I think that is very important because, as I said before, it is the primary duty of the government in making a proposal to review its conformity with the rule of law, but of course Parliament cannot take that for granted. So I think it is very important that within Parliament you have a special committee that is capable and is very well adequately supported to do that job, and that might help to increase the conformity of national legislation with the rule of law. And the same applies, of course, for the European Parliament, I think.
I think, apart from the matter of the internal structures that you may create, I think, personally, I'm a very firm believer in checks and balances. For me, that's actually the core of democracy. So you have to organize that the checks and balances are there, that they're strong. There are external forces able to scrutinize what the legislators and the executive are doing. That means transparency, as was raised in the previous session, but also the possibility for citizens and organizations to go to court, to challenge laws, for example, in court. It means strong civil society, and ultimately it also means that all of us, we have a responsibility in being extremely critical, and sometimes that means indeed being obnoxious, but in my view, that is our job. It means always asking critical questions, always looking at the laws. And I have to say, I've seen many examples in recent years where laws were passed, in particular in the area of counterterrorism, that were clearly, did not meet the standards of legality and constitutionality. And what you see then is that somebody is bound to go to court. The court will annul that piece of legislation, and then you have to start all over again. And there, I think, if that happens systematically, then we as legislators, as parliamentarians, are not doing our jobs properly.
Is there enough inter-parliamentary dialogue? Do we learn enough from each other?
Between the European Parliament and national parliaments? No, not nearly. That's why I'm very pleased that we're having this session here today, because again, in my report, this is one of the things we'll be proposing, to have an annual debate between the national parliaments and the European Parliament. I hope also between the national parliaments themselves, but more importantly, within the national parliaments. You were talking this morning about working with the system of rapporteurs. Well, if I can have the audacity of making a little suggestion, well, maybe you could appoint a rapporteur for the topic of democracy, the rule of law, and fundamental rights. But no, I think it is time, and this is also part of the European Union becoming more mature in this on this dimension. The fact that the parliamentary dimension of democratic governance, the rule of law, and fundamental rights will be strengthened.
Okay. Thank you both very much indeed. If you could stay on the stage while we take some questions from the floor. I'll take 3 questions at a time, if that's acceptable to the chair. So could I please begin with Mr. Mahou, please?
Thank you, Chairman. I've got 3 points very quickly. Now, personally, I'm a member of the Venice Commission. And the Venice Commission deals with issues which affect member states. Now, in more specific terms, I'd like to refer to CETA. Now, we hear that the Commission and some lawyers take the view that this is not going to be a mixed treaty. What are the Commission's views of this? In other words, it would be a breach of the idea that guided the original negotiations. Now, either the treaty is going to be mixed or it is not. I think when it comes to arbitrary, the dispute settlement structures and so on, we have to consider this. My second point is what I heard said about the Venice Commission. The rule of law is an essential precondition, but it's not enough in itself to establish democracy. I think it's important to remember this and make it clear. I wonder if you could tell us what you think would be the criteria which perhaps the Venice Commission could put to parliamentary assemblies. But then my third point, there is a European Agency on Fundamental Rights based on Copenhagen criteria. Where does this leave, or what exactly is the role of this Agency of Fundamental Rights in the discussion we're having regarding the rule of law? Thank you.
Thank you very much indeed. And if we could just hold our any responses to that, and I call please Sir William Cash.
Thank you very much. I would just simply like to say I've got a very short time, so it's a big subject and one I've been intimately involved in since I was Shadow Attorney General in the beginning of this century in the United Kingdom. And I did in fact put forward the proposal for the repeal of the Human Rights Act because the real question we have to ask ourselves is very simple, and that is which law, who governs us and how, and the rule of which law. So that fundamentally we have to ask the first fundamental question, unless of course you agree in total universality, and we don't in the United Kingdom, which is why we've proposed a new British Bill of Rights, which was referred to in the Queen's speech. We are very much in favour of human rights, and if I might just remind some people, the fact is that we have fought for human rights, practically speaking, for centuries, and indeed most particularly in the aftermath of the 2 world wars. So in a nutshell, I'd simply say this, that we are devoted to human rights, but not this kind of human rights system which we now have. In fact, I brought in the Gender Equality Act, and I'd just simply like to make the point that we put democracy first and human rights to follow it.
Thank you very much indeed, Sir William. Can I call Mr. Gamero?
Thank you, yes. I would like to reply yes. What is the role of national parliaments in defending the rule of law and human rights? I would say that parliaments play a very important role. Now, if we want to be adults and mature rather than children, as Madam in 't Veld was saying, the fact that is that these are difficult questions. And the question we should try to answer, I think, is this. Are we not bound by the Charter of Fundamental Rights under the Lisbon Treaty? And what about Article 2 of the treaty? Aren't we bound by that? The guardian of the treaties is the European Commission. Now, shouldn't the European Council therefore take matters in its hands and decide whether decisions can be taken at a lower level or at intergovernmental level? Shouldn't the European Council and the European Commission express positions in line with these agreements? In the case, I would refer to the case where the European Commission is considering sanctions against one particular country because it misses the deficit figures by a few tenths. So, but when it comes to fundamental human rights issues, they don't act. So perhaps we should consider these issues. When shouldn't we be concentrating more on human rights rather than economic details?
Okay, thank you very much indeed. Can I ask our two panel members if they wish to just take a minute each to respond to any points in those three questions, and then we'll take some more questions from our list.
Okay, does this? Yes, it works. Well, first of all, because I can't answer all the questions, on TTIP, CETA, a mixed treaty, I think that is, to some extent, also a political question. It's just not just a legal question. To Mr. Cash, on international law overruling national law, well, I think if you sign up to a treaty or a convention, then you accept the fact voluntarily that you're bound by it and that it will also sometimes override national law, or that at least national law has to be in compliance with the common standards that you have agreed upon. And I recognize, and I said it also earlier, that sometimes democratic decisions sit uncomfortably with court rulings or the other way around, but I think that's also the nature of the beast. That's part of democracy, and I think it's quite good that certain constitutional principles are protected by a more difficult procedure to change them than regular laws. And then finally, to Mr. Gramero, the Charter of Fundamental Rights is binding to a degree, but there is a famous Article 51 which basically gives a kind of carve-out to the member states, which I think is silly. Because for me, fundamental rights are about applying certain standards, certain principles. So it's silly to say they apply at European level to European laws, but at national level you can violate them all you like. And I absolutely agree that we fully accept in all member states that the European Commission will start infringement procedures if indeed you break the budget deficit rules, or you give illegal state aid, or you violate the emission norms or whatever. But when it's about fundamental rights or the rule of law, then the European Union is very hands-off. And we in the European Parliament want to overcome that problem, and therefore we propose a mechanism which provides real tools, but which is also objective, that treats all member states equally, is not incident-driven, which is evidence-based, and which gives the European Union real tools to also uphold those values.
Okay, thank you, Sophie. Peter, did you to respond?
Yes, there was one question relating to the Venice Commission that the rule of law is not sufficient. Now, the official title of the Venice Commission is the Commission for Democracy Through Law, not through the rule of law, but through law. And of course, the rule of law, unless we give it such a broad meaning that it loses all its meaning, is not all that determines the quality of the legislation. But I think it would be quite an achievement if today and in the coming time we would at least agree on what the rule of law means and how we can put that into effect. But then of course there are other rules that also have to be respected. We are all, I think, aware of the British tradition of human rights. We admire the British tradition, but it has had an enormous impact on the development of the human rights protection in Europe. If you see the case law of the European Court of Human Rights, you will see that the common law of Britain has had an enormous impact. So I think in that respect, Britain cannot complain. And if you say that you don't like the present system, well, as Mrs. Intveld said, you are part of it, whether you like it or not, as long as you are a member state of the European. You have to accept it. But you can, of course, always try to influence it in a positive way.
Okay, thank you very much. I'm now going to take 3 more questions. Could I call Mr. Ilčić, please? You could indicate where he is.
Thank you. I'll speak in Croatian.
Thank you.
I would like to agree that the rule of law in general terms is one of the fundamental values shared by all the member states. But here we are using the concept European values, and I think that this concept has not been defined enough. We are also aware of the fact that there are different concepts and different interpretations of the concepts of human rights. If European values are those that are seen in the lifestyle of Europeans, then we have a problem here. A dramatic low rate of fertility shows that we definitely have a problem with the fundamental values in the sense of value of life. Member states have different systems of values, and therefore I think that we should not accept new norms that would make pressure on member states to show some weaknesses. I think that we should give subsidiarity to member states to decide by themselves. Thank you very much.
Thank you very much. Can I call Mr. Krichboom, please?
Thank you very much, Chairman. Firstly, I'd like to say how glad I am that this topic is on today's agenda. I think the state is the underpinning of everything, particularly of democracy. But in our member states, let's be quite honest about this, there are some real shortcomings here. What about after elections? If parties find themselves in the majority, either on their own or in a coalition, they often carry out a full power grab. And sometimes it's amounted almost as if they're taking over the very state itself. But here we need to have the protection of the minority by the majority. A minority is legitimate in a democracy and must have the chance of becoming a majority at some point. It seems to me that we have a great deal of progress to make on this front. I'd like to thank Frans Timmermans for what he said today, not just because as first Vice President of the Commission, but also because he made the question of the rule of law into one of the priorities of his term of office as a minister. He was too humble to mention it himself, but the Netherlands and Germany and other countries took action on this front, but it was Frans Timmermans and the Netherlands who launched the whole effort. I therefore am firmly convinced that here we're not talking about small fry. We need to have checks and balances very much in the rule of law. I would therefore like to launch a plea. Can we please take this more seriously? It's a matter of that every state must do for itself. It's only if we do that that we can be credible. And it's only if we are credible that the general public in Europe will have confidence in us. That's the most important thing if we want to make the EU survivable into the future. Thank you.
Thank you very much. Can I call Ms. Giannetti, please?
Thank you very much. Well, basically we're talking about setting up an effective mechanism for monitoring the way that the procedure under Article 7 works, where we want to prevent violations, but make sure we have proper proportionate sanctions and make sure that the rule of law is indeed defended in all 28 member states. May I recall that the Foreign General Affairs Council did establish a monitoring procedure with an annual report. The last one was the 25th of May this year under the Dutch presidency. I believe it's necessary to make sure we have coordination between the mechanisms that member states have established in the European Council and the mechanism that was referred to in the European Parliament's proposal recently submitted, where you would have parliamentary debate and interparliamentary debate as well. So this mechanism would address the annual report on the respect for the principle of rule of law. And this would be a commitment amongst all the 28 member states and the European Parliament.
Thank you very much. I'm going to take one more because we've still got quite a long list of speakers. So can I also call Ms. Auroy, please? Yes, Madame Auroy.
Thank you, sir. May I add to what my colleague Mr. Mahou was saying? There's a very important point here, the question of subsidiarity. As our colleague from the European Parliament was saying, we do need to consider subsidiarity. We cannot agree with our Croatian colleagues saying that everybody can do whatever they want at home, regardless of Schengen. So how can we comply with subsidiarity in the Schengen area as well? Another point now, the classic question of soft law and hard law, as we call it in French. When we are told that the big multinationals act, and there we have a green card, and we look at their behavior vis-à-vis their affiliates and their subsidiaries, we see that it's all very well to have a lovely charter and to have good practices, but they do not want European law to apply to them. Don't you think there's a contradiction there? And don't you think it's the role of parliamentarians to speak out in this type of situation where we see what happens in the international economy and the European economy? The European scale is perhaps not the right scale. We are not only members of the European Union, we are also MPs from our national parliaments.
Okay, thank you very much indeed. I'm going to close the list of questions now. I'll just ask our panel to respond to those last 4 questions if they wish to. If you could be fairly brief, and then we'll take the last 4 questions. Thank you.
Well, I may be very naive, but I still believe in common values. The common values are expressed in the preamble of the Statute of the Council of Europe. They are expressed and laid down in the preamble of the European Convention. They are part of the Treaty on the European Union in Article 2. So, and I think our whole effort in the integration in organizations is to protect common values. But of course, common values doesn't mean that you have to have exactly the same opinions about all the rules to implement those common values. And to go to your example, I think we all agree on the value of the protection of human life. But that doesn't mean that you cannot have legislation in your own country that gives a certain expression to the protection of unborn life. That the European Court of Human Rights has made it very clearly that at the moment there is not yet a common standard about the protection of unborn life, and therefore there is a certain margin of appreciation left to the member states. And as far as the majority in Parliament is concerned, well, yes, we speak about the rule of law, we don't speak about the rule of majority. And as I said before, the relationship, one of the most important elements of the relationship between democracy and the rule of law is precisely that within a democracy, the majority has also to give enough leeway to the minority in order to give all the people of the country the possibility to express in what way they want to be administrated. Thank you.
Okay. Yeah, I'll try to be very brief in reply to Mrs. Ginetti, without going into the details of the report, which is on the website, incidentally. Yes, we're going to try and find a process in which we will gradually integrate all the existing mechanisms, because there are many. We don't need to reinvent the wheel, and we can be very effective if we just integrate what's there. To Mrs. Auroy, I very much agree with your remarks about subsidiarity and about essentially what you're saying, if I understood correctly, applying the law to multinationals, to cross-border companies. Yes, I think everybody would agree with you, but it's also my experience as a member of the European Parliament that as soon as you want to apply something to a company based in one particular country, that everybody forgets all their principles and they're all up in arms to protect their own national champions, and this is something that all the member states do, all of them. Mr. Kirschbaum, I fully, wholeheartedly agree with you 100%. And then finally, Mr. Ilčić, here, first of all, I fully respect your views, the right to have your views. But here I'll make a very personal remark, which is maybe a bit off topic. But I find them a bit painful, because when you talk about lifestyle, I imagine you're also referring to same-sex couples. And I find precisely on a day like today, I find that extremely painful. Yesterday, I was in Kiev with a delegation of the European Parliament, and we marched with the Gay Pride that took place in Kiev in a peaceful manner for the very first time. It took 6,000 police officers to protect it because there were some neo-Nazi homophobic hooligans who had promised a bloodbath. Well, fortunately, that didn't take place in Kiev. Unfortunately, it did take place in Orlando. So I can say here firmly, in the treaties, in the Charter of Fundamental Rights, in the Convention on Human Rights, it states everywhere that everybody will be treated equally, regardless of sexual orientation or indeed identity. And I stand firmly by that. And yes, there are margins of appreciation, but that means margins as well as appreciation. And I don't think that subsidiarity means going outside those margins. The European Union is about values, and that applies to everybody, without discrimination.
Thank you, Sophie. We've got time. We've got time to take 4 more questions from the floor, with a short response from our 2 panelists, and then we'll have to bring this part of the panel to a close. So could I ask Mr. Cordery, please, to take the floor?
Oui, merci.
Thank you very much, sir. On the question of human rights and the rule of law, we speak out quite vociferously whenever we talk about following the Copenhagen criteria when acceding to the European Union. That's a good thing. We're less vociferous when we talk about complying with these same rules and criteria when we're actually a member state. Today, we are looking at 2 countries in particular which systematically ignore all of the recommendations that have emerged from the European Commission and other European institutions. I would like to ask the following question. How can we make sure that we have coercive measures to make sure that our rules are followed by the member states? And also, as COSAC, as national parliaments, how can we make this subject a green card in the future in order to deal with the situation of these 2 countries and to assess whether there is a violation of the fundamental rights under Article 7 of the European Treaty?
Merci, Monsieur Cordery. And can I call, please, Mr. Obremski?
Ladies and gentlemen, in the discussion about rules of law and democracy, I'd like to concentrate on the deficit of democracy. It doesn't just result from our European circumstances. It's not just for leaving out on transparency in order to make the European Commission efficient because of the financial crisis. We have the crisis of the democracy because the decision-making on democracy was shifted to lawyers and specialists from parliamentaries. There is also a discussion in one of the books of one of the experts about this type of action. The implement of these experts causes a feeling of fear among voters and parliamentarists. And this is also about fight of humans against terrorism. Can we imagine a different answer than searching for a balance between safety and freedom in the current world? Can it be something better when sovereign national parliaments decide, and can we replace it with another solution? Because today we have to sometimes partially restrict our freedoms in order to provide safety.
Thank you. Can I now ask Mr. Mora, please, to take the floor?
Thank you, sir. Spain was one of the most pro-European countries in the history of its recent democracy. But the latest polls tell us that there is a rise in Euroscepticism amongst Spaniards. More specifically, the latest poll that we've seen says that in the last 3 years, we've seen a 20% rise in Euroscepticism in Spain, which is now about 60%. But the poll also tells us that the inside or outside of Europe, that when Spaniards would prefer to stay in. Now, clearly, we're in a crisis. There is a rise in Euroscepticism and populism in Spain. This has to do with economic reasons, but also it has to do with political reasons. And that is, in some cases, we've seen a lack of respect for the values of the European Union, and we have departed from these rights and values to a certain extent. Now, I was in the ALDE group in the European Parliament. There was a proposal for a European semester that was made at the time for fulfillment of human rights and democratic values in European democracies. Would it be possible to have a European semester as well for the European institutions along those lines, and more specifically the European Council? Thank you.
Thank you very much. And a last question, please, or comment from the floor from Baroness Faulkner, please. Thank you.
Thank you. I think what I found missing in the discussion today has been the role of constitutionalism in upholding the rule of law and protecting democracy. And until you have separation of powers between the executive, the legislature, and the judiciary, you're not going to have the capability for challenge when there is abuse of the use of law or human rights. And it seems to me that we still have, this is in terms of the Copenhagen criteria, that we still have too many countries in the EU where there isn't a formal constitutional separation between parliamentarians and the judiciary. We know from the documents we've got in front of us today that there are countries where parliamentarians appoint judges, where parliamentarians intervene with judges, and other countries where they're politically appointed. So until you have that very clear distinction between judicial independence, you're always going to have edges where there is political interference, and that, of course, in some sense is a limited but arbitrary use of power.
Thank you very much indeed. I'm now going to ask our two experts to respond to those questions in about a minute to a minute and a half each, if possible, please. And apologies to those who wanted to contribute from the floor and we haven't had time to hear from you. My apologies. Peter.
Well, almost all questions refer to the European Union rather than to the Council of Europe, so I have not much to say. I only want to say, as far as the last aspect is concerned, that the Venice Commission adopted very recent opinions about the independence of the judiciary, both in Poland and in Hungary. So I think those were very important, important opinions, and I hope that some action is taken on the basis of those opinions, because that's, of course, the Venice Commission can only give a legal opinion, but has no powers in itself to do anything about it. In that respect, I also want to remind you that one of the procedures under the European Convention has become absolutely obsolete, and that is the interstate complaint procedure. It worked in a preventive way in the case of Greece under the military regime. It might work also in other situations, and I think it would deserve some consideration. Thank you.
Thank you. Sophie.
Yes. First of all, to Mr. Corderi, who mentioned the example of two countries. Well, the essence of the report we're preparing in the European Parliament is precisely to come away from this incident-driven approach that is singling out countries, and countries feel that they're targeted unfairly, and instead have a kind of permanent reporting on all member states on an equal footing, and make it less, let's say, less sensitive, less politicized that way, more objective, and we hope that that is going to remove some of the obstacles and opposition. To Mr. Obremski about the balance between security and freedom, which is indeed an extremely delicate one, and where I personally feel that we've been rather careless with our freedoms in recent years. I don't think that there are necessarily better guarantees if we lift it from the national to the European level, but I do see that sometimes national governments are actually using the European route to circumvent national, let's say, constitutional requirements and the rule of law. Whatever they cannot get through their national parliaments, they'll take the European route. We call it policy laundering, and that is usually to the detriment of our freedoms. So we need to make sure that the guarantees are there both at national and European level. Thirdly, to my former colleague Fernando Maura, with a pleasure to see you again. I agree with you that this is the moment, more than any other time in history, that we should stand up for our shared values. And what we propose is a European semester, i.e. a process which is very similar to the semester we have in the Eurozone with this permanent monitoring that I just referred to, and an annual debate, an annual parliamentary debate. And finally to Baroness Faulkner, also great pleasure to see you again after so many years. On the separation and constitutionalism, indeed, this is something that this is precisely, an example of the kind of topics that we need to elaborate and define together. Because if you look at the United States, Europe has been incredibly critical of the fight there has been for the appointment of a judge to the Supreme Court, which has been completely politicized. Yet nobody would say that the United States are not a democracy. As long as we can agree on the principles, and I think that they have been elaborated in a fantastic way by the Venice Commission in the checklist, for example, but then we need to talk about how do you apply it in a national context or indeed a European context, because yes, to the question of Fernando, monitoring the EU institutions will be part of the process that we propose in the report, because the European institutions pass laws and execute laws, implement them in practice, so they should be subject to scrutiny just like member state processes. Thank you.
Thank you very much indeed, Sophie, and thank you too to Peter. I'd like to thank our two panelists for their contributions to our discussion and all those contributions from the floor. It's been an extremely interesting discussion from my point of view. I will take back to my own parliament many of the views that I've heard expressed here and forward into the Human Rights Council discussion, which will take place in Geneva next week. So many thanks to you all for your contributions, and I'll now hand back to our chair. Thank you.
And thank you very much, Mr. Hunt. It was a very interesting panel session and discussion with the plenary debate as well. Thank you very much. I would now like to invite Commissioner Timmermans again to take the floor for some closing remarks on this topic. Please, you have the floor.
Thank you very much, Chairman. Thank you very much for this opportunity after a fascinating discussion. If I may, just a few brief remarks. I was listening to this debate about the tension between democracy and the rule of law, which actually is a subject that was started by John Adams at the end of the 18th century when he said that democracy, if unchecked by law, turns into the tyranny of the majority. And I believe, and this was further developed by John Stuart Mill in the 19th century, and I think we still have to look into the core elements of this discussion. What is democracy? Is democracy the imposition of the will of the majority on everyone? Or is the essence of democracy that he or she who is part of a majority knows that in a democracy they are protected by law, even against the will or the whim of the majority? I think if we've learned anything in the course of European history, then we know that democracy on its own is not enough of a guarantor for the individual or collective rights and freedoms of our citizens. If we know anything about the construction of Europe, be it in the Council of Europe or the European Union, we know that we need this tripod of equal elements: democracy, respect for human rights, and the rule of law. And you cannot set up one against the other. You cannot say that one is more important than the other. Only in the full respect of the three of them can you develop into a pluriform, democratic society where the majority knows that they have the right to adopt laws, but the minority knows that they are respected in their fundamental rights by the same laws. And I think this is an essential element, and should be an essential element in our debates. And to have this function in the right way, we need to guarantee the separation of powers. We need state institutions to respect each other's role in a rule of law governed state. So you cannot have a go, because you won the election, at the judiciary. Or the judiciary cannot neglect the wishes of the elected officials in a democracy. And of course, democracy allows you to change the constitution, but you have to abide by the rules of the constitution when you change the constitution, and not just say, because we have a majority, we now determine by simple votes what the constitution should be like. And I think these elements should be essential in the way we view this across the European Union. Now, there are many reasons why this is not something that is up for subsidiarity, that everybody can make their own rules. Many reasons pertaining to our own history, to the collective acknowledgement of human rights and the rule of law, to international and European treaties signed and ratified by sovereign parliaments. There's no imposition here. It was decided and signed and ratified by national parliaments. But there's one more specific reason in the European Union that was not discussed by the panel that I want to mention. For the European Union to function, we need to be sure that European law is applied in a uniform way in every single member state. Much of European law needs to be transposed by national authorities. This act of transposition is checked by an independent judiciary that then looks whether what the national government has done is in compliance with its European obligations. If the judge isn't sure, the judge can go to Luxembourg and ask for guidance from our court in Luxembourg. Now, this system, which is essential for citizens' rights, but also for the operation of our entrepreneurs across the European Union, which can only happen if there is uniformity in application of EU law, this system depends fully on the independence of national judiciary. This depends fully that national judiciary will not be steered by political considerations of national governments. So it's not just about the issue you discussed earlier about fundamental rights and rule of law. It is about the very fundamental issue of the functioning of the European Union also as an internal market, as an area of uniform application of EU law. So please take that into consideration when discussing these issues at home. I think I, from the European Commission, would highly welcome a greater involvement of national parliaments in this debate. I think it is timely and important, but I would really urge you to look upon it also from the angle of European citizens having rights on the European level, whether they are individual citizens seeking a job in another member state, or when they are entrepreneurs trying to establish a business in another member state, counting on the same level of legal protection and the same application of law in every single member state. Thank you very much for this opportunity to share my thoughts with you on this very important topic. Thank you.
Thank you very much, Mr. Timmermans, for your insightful comments regarding the protection of the rule of law in Europe. After this substantive session, it is now time for a coffee break. Coffee will be served in the Kelderzaal and in the Rolzaal to your right. Please make sure that you are back in this room at 3 p.m. Dear colleagues, ladies and gentlemen, it's time now to start the third session of this conference about the exchange of best practices in parliamentary diplomacy. To guide us through the various aspects of this field, we have selected a panel with representatives from national parliaments. This debate will be moderated by Mr. Jan Wouters of the University of Leuven, of the research project Interparliamentary Cooperation in the EU's External Action, Parliamentary Scrutiny and Diplomacy in the European Union and beyond. Mr. Wouters, may I ask you to take the floor, please?
Your Excellencies, distinguished members of Parliament, ladies and gentlemen, it is a great honor to moderate this session on exchanging best practices and experiences among parliamentarians in parliamentary diplomacy. My sincere thanks to the Dutch presidency for its kind invitation. And as the chair already announced, this invitation is probably due to the fact that I, as a Jean Monnet chair at the University of Leuven, am currently leading a Jean Monnet network called Interparliamentary Cooperation in the European Union's External Action, Parliamentary Scrutiny and Diplomacy in the EU and beyond. The shortcut of this long name is PACO. And PACO, as a project, brings together three interrelated teaching and research areas: EU external relations, interparliamentary cooperation, and parliamentary diplomacy. Now, please allow me to share with you some introductory remarks before we turn to our eminent panel and before we open up the whole floor for interactive discussions. I would first like to share a few thoughts with you regarding the notion of parliamentary diplomacy. And secondly, I would like to go with you through a number of important questions that parliamentary diplomacy triggers. First of all, what is parliamentary diplomacy? It has been defined as follows: the full range of international activities undertaken by parliamentarians in order to, firstly, increase mutual understanding between countries. Secondly, in order to assist each other in improving the control of governments and the representation of a people. And thirdly, in order to increase the democratic legitimacy of intergovernmental institutions. Now that is a mouthful. And these are a lot of functions: mutual understanding, control, or if you wish, scrutiny of governments, increasing the democratic legitimacy of international organizations. But most of all, the very concept of parliamentary diplomacy sounds probably a bit misleading, because in the narrow sense of the word, diplomacy is about promoting state interests, negotiating treaties, representing governments, not necessarily things that are all the time associated with parliaments. But I do want to avoid a conceptual trench war here. And one thing is clear, that there is a growing sensitivity in parliaments, not just in Europe, but I think worldwide, that in a globalized and ever more interdependent world, foreign policy and international politics have become so important for the lives of all of us that the public is rightly asking for more transparency. And as you see, transparency is one of those buzzwords which clearly springs out from the word cloud that is displayed here. Parliaments as institutions, but also individual members of parliament, such as you, as the elected representatives of citizens, are increasingly expected to contribute to engaging in complex European and international issues that impact on people's lives. This is also confirmed in the Guide to Good Practice on Parliament and Democracy in the 21st Century, written by the IPU. I read from its section on Parliament's involvement in international affairs, and I quote, "Today, the distinction between foreign and international and national or domestic has become increasingly blurred. Parliaments must therefore step beyond the traditional executive prerogative in international affairs and subject governments to the same degree of oversight as in the domestic policy arena." End of quote. That's my set of reflections about the notion of parliamentary diplomacy. Now let me introduce a couple of important questions triggered by parliamentary diplomacy. And there are many of those questions. What are the benefits of parliamentary diplomacy compared to traditional diplomatic tools? For example, in the context of the European Union's neighborhood policy. What type of diplomatic activities are parliamentarians engaged in? Are these activities of a structural nature, or are they rather ad hoc? How can parliaments learn from each other's experiences? Share best practices, also be aware of pitfalls. And is there a need for parliamentary diplomatic activities of national parliaments and of the European Parliament to be more coordinated? All kinds of questions. Now this may quickly lead us to a day long of extra discussions here. So in, say, consultation with the host, we singled out 3 questions which I would like us to focus on during the discussion in this session. You see them on the screen. The first question is, why should parliaments develop a proper diplomatic role for themselves? A second question, when engaging in parliamentary diplomacy, what internal and external consultation is desirable? And a third question, much more broadly, what are the challenges for conducting a genuine parliamentary diplomacy? Now, with your permission, I'm just going to say some teasers, if you wish, for our further discussion. First of all, why should parliaments develop a proper diplomatic role for themselves? That answer is definitely in the eye of the beholder. When one asks this question to a seasoned diplomat, one usually gets a quite different answer than when the question is being asked to a distinguished member of parliament with a long experience of parliamentary involvement in international affairs. You may note that the question is formulated with reference to a proper diplomatic role for parliaments. That does not mean necessarily a diplomatic role totally independent from the government. In many countries, indeed, parliamentary diplomatic initiatives take place in consultation with the government in question. We'll come to that back in the second question. But that, of course, does not preclude parliaments from deploying activities according to their own vision. Now, parliamentary traditions at the national level, at the European level, show interesting differences here. And I would be very grateful if indeed this distinguished audience could share some experiences in this respect. This being said, individual members of parliament may have their own visions also on their role in this respect. And they may also have their own doubts, as we can read also from the results of the survey in the biannual report. I could imagine indeed that both at the level of national parliaments and at the level of the European Parliament, some distinguished members worry about the possibly counterproductive effects of parliamentary diplomacy. Politicians may have their own agendas. They may urge to profile themselves. And this could, in some cases, undermine the subtle, long-term processes which diplomats, both at the national and at the European level, are conducting. So that is a challenge that we should talk about. Second question, when engaging in parliamentary diplomacy, what internal and external consultation is desirable? Well, quite a number of you, of your, say, colleagues, when filling in the questionnaire for the biannual report, call this internal and external consultation a challenge. So let us elaborate that question. Is consultation needed with the government? To just give one example, the French Assemblée indicated that it never expresses views which derogate from positions of the government. Is consultation desirable or even needed with other national parliaments and or with the European Parliament? What about internal consultation within your parliament? In most of the answers, we find that the speaker practices parliamentary diplomacy. Is this internally being coordinated with the relevant parliamentary committees? And speaking of consultation within committees, how is a delegation being composed? To what extent does one take into account the question of representation of minority fractions? Okay. Third question, what are the challenges for conducting a genuine parliamentary diplomacy? Here we could, of course, imagine a lot of challenges apart from the ones which we have actually already mentioned. Gathering the most relevant and up-to-date information, being able to digest all that information properly, the question of how to involve citizens in the conduct of parliamentary diplomacy, human and financial resources, time management, budget constraints, and so on and so forth. I'm sure you will share with us lots of those other challenges that you may be thinking of. That's the end of my presentation, and I would now like to turn to our three distinguished panel members, who each will make an intervention of around 10 minutes. So I now kindly invite the distinguished panel members to the floor. Let me use the time to already introduce them. The first one who will speak is Ms. Lolita Cigane. She's welcome. She's the chairperson of the European Affairs Committee of the Saeima in Latvia. The second panel member is Mr. Andrei Humko, who is a member of the Bundestag in Germany. And the third panel member to speak is Mr. Ruben Moreno Palanques, who is a member of the Congress of Deputies in Spain. So, now we get moving. This is also always tricky. Let's get started. So, can you please take the floor and share your experiences with us?
Yes, thank you so much, Mr. Chair, dear President. It's a great pleasure to be addressing you here, and it's a great pleasure to be sharing our experience on parliamentary diplomacy. I have to say that this COSAC format is an elegant and excellent format of multilateral parliamentary diplomacy. And I myself had a wonderful opportunity to enjoy it while my country, Latvia, for the first time held the presidency of the EU. And we had a chance to set the agenda and chair the sessions of COSAC. So, as a representative of a relatively small European Union member country, which joined just 11 years ago, I have to say that, now it's 12 already actually, I have to say that we really appreciate all possibilities of multilateral formats of parliamentary diplomacy where we can engage with our colleagues. And of course, the format of COSAC we all know, and there is no need to additionally speak for the benefits of it because we are feeling it as we participate in these conferences. But there are, of course, several other parliamentary multilateral formats which I personally have found very, very useful. And for the first, as a first thing, I would like to mention OSCE, Parliamentary Assembly, which brings together many more states outside also the European Union member countries. And this is a wonderful format because this is a wonderful platform where we can hear each other and make ourselves heard and listen to countries that represent completely different set of values and different regions from us. Although it's an organization for security and cooperation in Europe, luckily it has managed to include, for instance, Central Asian states. And where else would you find the possibility to engage with members of parliament from Mongolia, for instance, or the Central Asian countries, if you did not have the OSCE Parliamentary Assembly? So this is a wonderful format where we can learn about these regions. Because in our globalized world, I don't want to really share some truisms, but it is true that a region is remote only if the crisis has not hit it. Once a crisis hits it, it becomes a region that we have to take care of, us being part of the European Union. And the fact that we can engage in an organized format, for instance, with countries of Central Asia in OSCE PA is of course a wonderful opportunity. Similarly, also I'm very glad to always meet here in COSAC my colleagues whom I used to collaborate very closely at the Council of Europe Parliamentary Assembly known as PACE. That is a value-based organization that has a focus of human rights. And this is a wonderful platform where countries which are now arch enemies like Russia and Ukraine, Russia and Georgia, Armenia and Azerbaijan are all members. And they actually have to find a way how to engage with each other, how to explain their causes for the other members of parliament. On behalf of PACE, we've gone to observe elections in Azerbaijan, in Georgia, in Ukraine, and this is a wonderful tool of parliamentary diplomacy. But now I will probably talk a little more about bilateral parliamentary diplomacy because this is what I was asked to address and talk about. And just to make sure that I provoke some discussion, I will talk mainly about some dilemmas that I, as a representative of a relatively small and young European Union member state, which does not have a lot of resources and a lot of clout at the international arena, what are the dilemmas that we are sometimes facing, and also some of the advantages that being of our size and our influence, we do sometimes have. And the first dilemma that we sometimes look at is whether a country can be too small to engage in a genuine and meaningful parliamentary diplomacy. I already started off my little intervention with the fact that I mentioned that we held the presidency of the European Union, which shows that no European Union member state should be too small. But of course, there is a huge difference between a visit of, for instance, a German or French member of parliament to a country and a visit of a Latvian member of parliament to a country because of the clout that these two groups of countries have in international relations. However, sometimes the small is a huge advantage because being small, you do not have these preconceived ideas of who you are and who are you representing. There often is a lack of previous history and previous animosity. So sometimes you just come and start from a tabula rasa, so to say. And being too small sometimes is also a symbolic gesture. And here I would like to just mention one example, that my country, Latvia, after it renewed its independence in 1991, was first recognized by Iceland. Iceland has only over 300,000 people, but it was such an important symbolic gesture, so a lot of other recognitions from bigger member states followed. So for instance, being from Latvia, a country that used to be part of the Soviet Union, I felt that we've actually delivered a lot of support to other comparatively small countries in important regions, like Georgia, like Armenia. For instance, Armenians, after they turned their back to the association agreement with the European Union, they told to us, please, you understand our situation, don't give up on us. We'll be trying, we'll be engaging with the dialogue with you. So this is one dilemma. Does size matter in this aspect? Another thing that I am thinking of when thinking about the concept of parliamentary diplomacy is how and why do we engage with countries where the parliament was not elected in genuine elections as we know them, where we know that the parliament is just a formality, that maybe some kind of formal process of elections was organized there, and we know that very often the people we are supposed to meet there have been handpicked by the authoritative leader of the respective country. Should or should not we talk with them? During our presidency in the EU Council, I, for instance, was invited to go to 2 such countries where I was facing these dilemmas. One of them was Turkmenistan, one of the most closed countries in the world, and definitely the most closed country in the Central Asian region, and the second one was Belarus. We know that, for instance, reports of OSCE, ODIHR on Belarusian elections have not been complimentary at all, and to Turkmenistan, no one has ever gone to observe their elections. So my question was, should I go there? Should I talk to the members of parliament? And actually, while I was taking that decision, I was criticized by the civil society from Belarus who said, well, this was not a genuine election, why should you talk to them? Nevertheless, we took the decision, we discussed it, including, of course, with our foreign ministry, which was also a very important topic that was mentioned in the introductory speech. Of course, you want to align your policies with your foreign ministry and also the policies of the European Union, and I went there. And it was worth every minute I spent there, because there are important processes that are happening in both of those countries, in both of these regions. And there might be developments that might surprise us tomorrow. And in this way, going there, sitting down and discussing with the members of parliament, be them handpicked or not, it gives us an opportunity to really engage in the dialogue and to understand better what's going on in these countries. And finally, since I was asked to mention some of the examples from our experience, the last example that I would like to mention was the parliamentary meeting that we organized after the Riga summit, Eastern Partnership Summit, that took place during our presidency. Knowing that the whole Eastern Partnership issue is rather complicated, and knowing that Eastern partners, 6 countries that used to be also part of the former Soviet Union and that are on different tracks with the EU integration, were really expecting to receive some very favorable signals from the European Union as regards to their perspective of potential membership. We felt that also on behalf of the Parliament we should do some damage control, so to say. We knew that the Eastern Partnership Summit would not deliver some concrete promises for these countries. So we actually invited the members of parliaments of all 6 Eastern Partnership countries to discuss the outcomes in more detail and to also read in the statement and declaration of the summit positive signals for them. And also probably talk about the reasons why some certain progress has not been made. It was a wonderful meeting that our partners really appreciated, and thus we played our small but important role in this aspect within the realm of parliamentary diplomacy. So my time is up. Thank you.
Wonderful. Thank you. Thank you so much for enriching our discussions with a number of very important considerations, the experiences in the OSCE Parliamentary Assembly, and you know that Europe is rich in many parliamentary assemblies. Your experience with the Latvian presidency, what if you are a smaller player, what can you do? How can you engage with parliaments that are not necessarily as democratically legitimated as parliaments within the European Union? So thank you for sharing that with us. We now turn to Mr. Hunko for sharing his experiences with us. Please.
Thank you very much. If it's possible, I would like to speak in German. It's easier for me to refer to my mother language. Erstmal vielen Dank.
First of all, thank you very much for inviting me to join you and discuss this very important topic. In common with the previous speaker, I've got a kind of two-pronged approach to this question. Firstly, I look at it from the point of view of the German House of Representatives. And secondly, I look from the point of view of the Council of Europe Parliamentary Assembly. I think I would say that parliamentary diplomacy should be recognized and named as such. Many people are puzzled when you mention parliamentary diplomacy and they ask you what on earth it is. As I see it, it is a vital part of parliamentary work and can be summed up as being the total of all international relations that a parliament has. And of course, that the MPs have. It is work that's done by a great deal of travelling, committees of parliamentarians going off on visits. For example, the German House of Representatives carries out friendship visits around the whole world. Sometimes they visit one single country, or sometimes they go around several countries in a region. One special point I would like to emphasize, which I think is relevant to the German House of Representatives, is the program called Members of Parliament Protect Members of Parliament. This was launched in 2003, and it's based on recommendations from the International Parliamentary Union, IPU. The idea is to provide protection for members of parliaments who live in countries in which they are in danger of repression, or people who are even already in prison. It's quite a successful program, and I think that every individual membership of the German House of Representatives can enter into partnership with individual members of parliament in other countries, and not only with members of parliament, but also with committees and so on. And the decisive factor here is if these members of parliament get involved in the program, then they are involved in the House of Representatives Human Rights Committee. I was recently in touch with a group of Turkish MPs from various parties who are now in prison. This led to them getting an official status, and that all members of the German House of Representatives are bound to raise the topic whenever it arises in the course of their work. I'd like to emphasize that parliaments are not governments. That's already been mentioned a moment ago. We have to bear in mind there are two different things. There are governments in parliament, there are also oppositions, and there's all kinds of different points of view, and parliaments are in a position to act more freely than governments. And they can adopt a different position, with a freer choice of positions, than governments can. Let me give you an example of what I mean. I'm sure you know that the German House of Representatives, a week and a half ago, adopted a resolution on the genocide in Armenia. And there was a very emphatic reaction from Turkey, including from the President of Turkey. And this is particularly directed at members of the German House of Representatives who have Turkish ancestry. And it was the Parliament and the President of Parliament who very clearly called upon these members of the German House of Representatives, took them explicitly under his protection, and sent out a clear message of a kind which could not have been issued through the government, through the official diplomatic channels. So parliaments are not governments, and this means that members of parliaments are in a position to carry out a broader exchange of ideas. And I think this is becoming more and more important. Parliamentary diplomacy has grown a great deal in recent years. It's become much more important, and I think that's a good thing too. I'd also like to say that parliamentary diplomacy, and indeed any diplomacy, is not just stuff to do when everything's going well. It's not just a question of cultivating good relations. I mean, it's good to have good relations. It's always a good thing. But diplomacy particularly has to focus on maintaining relations in bad circumstances. This morning, we were talking about the question of sanctions against Russia. I'd like to strike a critical note on this subject. The situation, as has been mentioned a moment ago, and I'm glad the question was raised, that PACE is one international body in which Russian members of parliament and Georgian members of parliament, Armenian members of parliament, Azeri members of parliament can all meet. But the current situation is that the Council of Europe is continuing to meet at government level, 47 ministers, but at parliamentary level there has been a halt to such contacts. The reason is that extensive sanctions were imposed on Russian members of the Parliamentary Assembly. They were excluded from the Parliamentary Assembly, and in the end the Russian delegate said they would no longer come during the current legislative period, which is a year each time. And come January, we'll see what happens. Yet I think that the members of the Assembly are taking very energetic steps to try to escape from this situation, because it is most undesirable to have dialogue at government level, ministerial level, but not at parliamentary level. Another point I'd like to raise at this point is the ever-increasing trend to impose sanctions on members of the Assembly, to establishing blacklists. There have been blacklists from the EU side imposed on Russian delegates and others, and then in return Russia issued a blacklist, blacklisting members of the European Parliament or members of PACE and members of the German House of Representatives and other national parliaments. And we had extensive debates because there are areas of territory such as Donbass and Crimea which are disputed in terms of sovereignty. But don't forget Nagorno-Karabakh and Transnistria, Abkhazia, Kosovo, North Cyprus, Western Sahara. There's an awfully long list. There is debate on these territories, and there is an increasing tendency of countries to blacklist members of the Parliamentary Assembly who, in that country's view, are taking an incorrect view. This includes me. I'm on a blacklist. Ukraine has blacklisted me, which means that I was not able to do the work I'm supposed to do on behalf of Ukraine in the European Parliament. So the situation we have is that, on the one hand, parliamentary diplomacy is growing in importance and becoming more intensive. But at the other side, the protection of members of parliament is not making such rapid progress. So at government level, you have the fullest diplomatic protection for members of governments. But parliamentary protection is lagging behind. That is something which needs attention. And I think that PACE needs to talk about this, and they're going to be producing a report. I beg your pardon, the report came out in January with a resolution condemning this trend towards blacklisting members of parliaments. I think that's a good thing. I'm glad that COSAC is addressing the question of parliamentary diplomacy. It shouldn't only be the EU and its immediate neighbours that concern us. We should cast our eyes across all of Europe, which is much bigger. I think if we, resolution part 7 deals with this well, and thank you for listening to me.
I congratulate you also for your punctuality. Yeah. But we know this is one of your national characteristics as well. So thank you so much for sharing, like the first panelist, indeed. Thanks for sharing your experiences with us. I think indeed it's important also to draw lessons from the Council of Europe Parliamentary Assembly, what you have been saying also with regard to the rise in parliamentary diplomacy, but on the other hand, let's say a bit the lack of a proper, say, expanded protection for members of parliament is a very interesting kind of challenge indeed. So, maybe now turn to our third distinguished panel member, Mr. Ruben Moreno Palanques.
Thank you so much, and thanks for the invitation to take part of this discussion. As Andrei, as you know, you have a simultaneous translation. I will speak in Spanish from now on, if you don't mind.
Yes, I think that we've spoken really very little about parliamentary diplomacy. It's not very well known, really. The moderator quite rightly defined it at the outset. If you look at the Oxford Dictionary at the meaning of diplomacy, it's defined as the art or trade of a diplomat. Well, most of us here today could probably not be diplomats, strictly speaking. In most countries, in Spain this is certainly the case, diplomacy is within the exclusive prerogative of our governments. In fact, this is established in our constitution. So, if we would like to carry out diplomacy in the strictest sense, the Spanish Parliament could not do this. And I think that this should continue to be the exclusive competence of government. And that's because of two characteristics that must be featured in traditional diplomacy and in its results. That is effectiveness and consistency. If slow justice is not justice, then I would say that diplomacy, which is not well focused or is spread too far and wide, ends up not being diplomacy. So we would have to have certain criteria for those who exercise diplomacy. Now, on a lighter note, we had a speaker in the chamber in Spain in the past who said that parliamentary diplomacy was for the easy questions, and if we had any difficult questions, we should send them to the foreign ministry. Of course, that's an exaggeration. But sometimes we wonder if we eliminate diplomacy and just refer to parliamentary, would we have more problems as we try to carry out our parliamentary work or not? Now, if diplomacy is within the exclusive competence of government in most countries, then, as I understand it, national parliaments have a role to play nonetheless, amongst other things, because the world has changed an awful lot. Look at communications, technology, globalization, soft power. And when I say soft power, that's when we try to achieve something with the carrot rather than the stick. Now, sometimes coercion is necessary. Now, the three of us here have been members of Council of Europe. And in the negotiations amongst countries, we see sometimes that it's a very hard game indeed. People take a very tough stance. So I'm not sure that national parliaments should play that role, and I'm not sure whether that's a strength of a national parliament, even though it is a strength of traditional diplomacy and our governments. Now, on the other hand, we have different characteristics which can be helpful. First of all, we can provide information. We represent on a pluralistic basis. We're committed to democratic ideals. Of course, our governments are as well, but the parliament generally reflects all of the different parties voted for by our people. And that is the case, at least, in social democracies in Europe. Now, the first two characteristics I mentioned, informality and representative pluralism, are advantages, but in some cases they can turn out to be disadvantages, especially if we're informal. A diplomat it must work continuously and constantly over a long period of time and have the appropriate focus. And sometimes changes take place. And, for example, on the 26th of June, we have elections in Spain. We may end up with a different parliament. Whether or not the government changes will depend on the parliamentary dynamics. Now, we're talking about each of our experiences in our various parliaments. We exercise diplomacy using various types of instruments or tools, and we're proud of some of them, actually. The highest level of representation is the President of the Congress, who goes on diplomatic visits, and sometimes members of parliament go on mission to other countries. This is soft power. Sometimes we have the Foreign Affairs Minister telling us that we should go on mission in order to solve problems, and sometimes it might be easier for us, but of course we're always under the supervision of the Foreign Affairs Ministry. And then you have the Foreign Affairs Committee, which can go on missions. These are more technical visits. There are annual forums where we have bilateral dialogues, which take place prior to the bilateral meetings between our governments, who try to resolve their bilateral relations. And then, of course, there's cooperation amongst parliaments. In the case of Spain, logically, we concentrate more in Europe. We all have similar mechanisms here. And we, as Spain, also concentrate a lot on North Africa and Latin America. It's very important for our European values, not perhaps to be exported, but at least be made known to our counterparts in North Africa and Latin America. I think this is a diplomatic task that we can carry out and which will not be done by a foreign affairs minister, even though that we may collaborate together in this process. So we've got election observation missions through the OSCE mainly, but in Latin America we do this independently as well. The Spanish Parliament does send MPs on mission, and of course we have the international parliamentary assemblies in which we all participate. Now, in the case of cooperation, we do have courses for parliamentary advisors in Madrid, and we have Ibero-American centers in Cartagena de Indias, in Montevideo, and members of the Spanish Parliament go to these precisely to learn about diplomacy and to work together with or study together with officials from various parliaments. And there they concentrate on specific themes, for example, parliamentary scrutiny over the executive, or say transparency of parliamentary administration or legislative technique. This is very useful, and these courses are very much in demand. And many people who've studied there have been more than 1,000 people so far, are now in positions of great responsibility in their own countries. Now, in the time that remains, I would like to say something about consultation and cooperation, well, internally or externally. Yes, of course, with our government, we work together, and in particular, as I said, with the Foreign Ministry. And sometimes we feel like our Foreign Ministry is a government within our government, but that's on a lighter note. We try to work together with the Foreign Affairs Ministry in order to avoid chaos. And externally, well, at the level of the European Union, of course, there's a major challenge to be met for the European External Action Service. And one of the criticisms that have been lodged by European is that we don't have a European foreign policy. And it's not that we don't have one, it's just that we can't agree amongst ourselves on what we want for foreign policy. So this is a challenge we're facing. And this can be part of our parliamentary work in the area of diplomacy, that is, coordination and consultation at European level. And of course, the same goes for international level, where European countries can group together to go to the international arena and solve some problems. I think that the greatest challenge to parliamentary diplomacy is, and this is by way of conclusion, is the fact that our constitutions, ordinarily speaking, our constitutions do not allow genuine parliamentary diplomacy. So as I see it, we need to try to strike the right balance and to coordinate appropriately between traditional diplomacy and what we may call parliamentary diplomacy. We might call it something else, but in any case, I'm referring to the work that we can do as members of Parliament at European level and indeed at international level. Thank you.
Thank you so much. This was, I think, again, a great intervention with new accents, new experiences, also pointing out to the fact that, yes, the legal or constitutional basis for initiatives for parliamentary diplomacy may not always be obvious, but it's great to hear what you are doing and the kind of, experiences we can learn from Spain. We have now had 3 distinguished panel members sharing with us experiences from Latvia, from Germany, from Spain. It's high time we now turn to you for some exchanges, and I see we have a couple of distinguished members already on our list. I think we're supposed to give you 1 minute for your intervention, so please try to be concise. Let's start with Mr. Simon Sutour. On ne vous entend pas.
We can't hear you, sir. Right, we can hear you now, thank you. That's now, as we've heard, diplomacy is an executive task rather than a parliamentary one. But parliamentary diplomacy is playing an ever greater role in the international game. And we'd like to see what is happening in terms of explaining the international scene to the public. Now, it's very useful to have conversations with the opposite numbers in other countries, and sometimes we can come up with resolutions. For example, the French Senate voted last Wednesday by 301 to 16 in favor of a resolution calling upon our government to work to lift personal sanctions against Russian members of parliament and to lift economic sanctions against Russia, as and when the Minsk agreement is put into action. Now, the government may ignore this resolution, but it cannot ignore it completely at the next council in June. The European Parliament is now going to be speaking on the main topic, and we think they will speak along the same lines.
Merci beaucoup.
Thank you very much.
Well, we are going to collect a number of other questions, if we may. So I now call on Mr. Yves Pozzo di Borgo.
Oui, ce matin, le Premier ministre...
Yes, this morning, the Dutch Prime Minister intimated that Brussels was a technocratic monstrosity and that the European Parliament has very little power. And it is therefore a matter for national parliaments to express their opinions and wishes of the European peoples. Well, now there is an European Union foreign policy. Of course, it's based on compromises, but it is backed by our 28 heads of state and government who meet in secret. Now, this foreign policy takes place without proper analysis by the peoples and parliaments of Europe. The European Council could talk about European security, the agreement with Turkey, sanctions. What parliament is consulted on this issue? Very quickly to finish off, if I may, I would like to see COSAC being much more involved with the agenda of the Council of Europe every time it meets. Thank you.
Okay, I now call upon Ms. Regina Bastos.
Good afternoon. I'd like to congratulate the Dutch presidency for the excellent work they've been doing over the last 6 months. Diplomacy is a concept which is evolving. Its dynamics cannot simply be summed up as being within the exclusive competence of governments. I think that we need to work together with our governments. The Portuguese Parliament has a good example that's been on for the last 14 years, involving cooperative actions in East Timor. The objective of this type of diplomacy, working together with the government, was very clear. We wanted to help them establish an independent parliament, and they were to be able to scrutinize their executive. We've also carried out important cooperative action with parliaments in Africa, in Asia, and Tunisia is an example of that. I would very much like to highlight the fact that we have focused our attention on Portuguese-speaking countries so that their parliaments, technically speaking, can develop to consolidate their democracies. It's very important to consolidate democracies in these countries. Thank you.
Thank you so much. There are other people on the list, don't worry, your time will come, but I just checking with our panelists whether they would like to react to some of the questions. Please, Ms. Sigane.
Yes, I think a very legitimate question was asked about what we do in parliamentary diplomacy, how do we explain it to our own population and voters? And I think that being politicians going through electoral circles, many of us see that very often the work we do internationally, and sometimes we do it, at least in our opinion, very well, it's not being appreciated by our population. But actually, I think we need to find a balance, because formats like this, COSAC formats and also PACE formats, they should actually be helping us to explain to our own populations in a much better way the challenges there are in the European Union, the dilemmas there are, and also the global trends. Because this is our duty to actually digest and bring this message to our population. So we should permanently strive to do that. And if we are talking about the secret council meetings, it really depends on the national arrangements in each parliament. Because, for instance, our European Affairs Committee, we review all government positions that go to the council, so we know what our government is speaking there. And we've talked at length here in COSAC about different practices. And the last point from Portugal, of course, every country has their own, so to say, competitive advantage when speaking to other countries. For instance, for my country, Latvia, we find it relatively easy to talk to countries which used to be part of the former Soviet Union, because this is a common legacy. Many of us also speak Russian, and this helps helps to find a common ground. And this is something, this diversity of Portugal, of other regions, is something that the European Union should be able to use in a much more skillful way in this multilateral and multi-faceted diplomacy.
Thank you so much. Mr. Junco?
Well, I'd like, if I may, to respond to the Spanish contribution for a moment, because it made it very plain to me that when you talk about parliamentary diplomacy, people in the various different member states have a very different idea of what it means. It is not a clearly defined term, and I think we have to go through a process of coming up with a common understanding of what it means. And then to respond to what we heard from France, it seems to me, well, one question regarding sanctions against Russia. It's possible to have one of many opinions. People will disagree, but I think it's fundamentally wrong to target individual members of parliament with sanctions, because I think that the parliamentary level is the level of all levels at which dialogue is possible, whereas at government level or bureaucratic administrative level is not so appropriate. I therefore am very much in favor of moving away from these sanctions, and I think Moscow should lift such sanctions as well. There should not be sanctions against individual members of parliaments. Then, we've got parliamentary elections in Germany next year, and it's difficult to travel and to do fact-finding. Back in January 2010, I joined the Council of Europe Parliamentary Assembly, and ever since then, I've always taken a very proactive stance regarding travelling. That is to say, I've always travelled very publicly. I've used Facebook and Twitter and so on to say, I am now travelling to such and such a country for such and such a reason, and I'm going to speak with such and such a person, and I hope to achieve such and such. I think it's, and this is why I think my journey is important. And what I've learned is, if you communicate what you're doing very openly like that, rather than meeting in quasi in secret, it goes down much better. I think that the voters don't complain if you go on a lot of journeys, as long as you make it very clear to them where you're going, why you're doing it, etc.
Mr. Moreno
Sí, que conste.
Well, I did not consult the Foreign Affairs Ministry to say what I'm about to say, but I agree with my colleague here, Andrei, that in the case of Russia, for instance, it's one thing to have sanctions at the executive level with another country. It's another thing to decide what to do with members of parliament. Really, they represent the will of the people and should not be subject to sanctions. Each country has its representatives, so the sanction, the penalty, should never be assessed against the members of parliament. Now, having said that, let me turn to the question of meetings prior to the European Council. This is very important in Spain, and I think in other countries as well. The Foreign Affairs Minister or the Secretary of State for the European Union will have to come along to these meetings to explain the position of the government for the upcoming European Council. What is the problem? Well, there are several. The first one is that the agenda is decided far too late. It changes right up to the last second. And secondly, even more importantly, governments somehow must have a general approach, but their hands have to be free. They mustn't have their hands tied. Reaching agreement amongst 28 member states would be impossible otherwise. So I think that a decision taken by government on behalf of its country is not against the accountability that vis-à-vis their own parliament. If a government takes a decision and the parliament doesn't like it, then we will ask our government to come to parliament and be accountable to us.
reaction from Mrs.
Yes,
Shigane?
since both fellow panelists mentioned the question of sanctions towards individuals in Russia, I just felt that I should also express my view, although there was no question directly asked about that. I believe that there shouldn't be any group of people that would be excluded from sanctions, because all people on the sanctions list have to be judged by their merit and involvement, including in aggression and aggressive moves towards neighboring states. So, judging by merit, there shouldn't be such thing as parliamentary immunity, because we've seen that, unfortunately, specifically in Russia, sometimes we've had situations where people have been hiding behind parliamentary immunity, although they have been indicted in other countries for serious crimes. So, no exclusion specifically for parliamentarians from my point of view.
Okay, great discussion, but it's high time we turn to the following question. So, Mr. Giovanni Mauro, please.
Grazie.
Thank you, Chairman. Just a year ago, the Policy Committee in the Italian Senate identified a critical point in the cohesion policy concerning the Mediterranean. And the committee in the Senate decided to take an initiative and investigate the situation. They appointed 2 members of parliament, one from the majority, one from the minority, to carry out this mission. They visited a number of countries around the Maghreb and countries around the Mediterranean with whom we have relations. They came back to the committee to discuss on the basis of data which were better than we might have had from the government or the Foreign Affairs Ministry, because they would have had to be politically correct, and they might not have been able to listen to the various political forces in those countries, in the parliament and out. But by just so doing, they were able to get a full picture of the situation. Now, the work of our committee led to a resolution adopted by the Italian Senate, and this became the letter from Florence, 26th of October 2015. And I think people here in COSAC are familiar with this. This is an example that I wanted to share with you of parliamentary diplomacy, where the Italian state, the Italian government, had intervened in the Florence conference, and they took note of our work from the Senate. And to conclude, I'd like to thank you once again for allowing me to speak and say that this is an avenue that we should explore. There's a lot of potential there. So, in the coming sessions, this is something we should focus on, because it has proven not only successful in our experience, but I'm sure that it would be very beneficial for the European Union as a whole, for our people, and for our parliaments as well as our governments.
So, let's turn to Mr. Tamas Meseric.
Thank you, Chair. First of all, I would like to thank you for giving me the floor. In fact, what I'm slightly missing from the discussion is the European Parliament, which happens to be one of those parliaments, if not the parliament, which has the most developed institutionalized elements of interparliamentary, interparliamentary diplomacy. Actually, we have standing delegations which most member states do not have for various regions in the world. Now, this has developed so far that actually by now we have a problem that informal groups called friendship groups try to do the same functions, try to perform the same functions as formal delegations do. Now, what I wanted to highlight simply is that there is an enormous room for...
Microphone, please. Maybe use your neighbor's microphone.
Okay, now that's some.
Okay.
So, just one more sentence. There is enormous room for synergies between the European Parliament, interparliamentary diplomacy, and member state interparliamentary diplomacies. Actually, delegation members can very easily facilitate member state interparliamentary diplomacy at the point of discussion, because they're usually received by heads of governments, by representatives of the executive, and this is important, all the more so for smaller member states. Thank you very much.
Thank you so much. It's important to add the dimension of interparliamentary diplomacy, I think, here. But we're going to still ask another distinguished member, Mr. Josef Viskupic.
Thank you. I have to say at first that it's a great topic for discussing here. And my point is that I didn't consult this with our Foreign Affairs Ministry, but that's why I can say this. I really agree that Parliament is not government, and that's why we have much free hands and much more freedom. What can I say? That the tools we can use as a parliamentary diplomacy is that we can in our parliament, such as formal friendship groups, but informal friendship groups. My friendship ties with the new president of Republic of China, Taiwan, is what? Is a diplomatic tie or political friendship tie? That's the point, and I think it's very good that we have such as informal friendship groups, and what I can mention is the cultural field for any parliaments we have in European Union, because I think all countries have cultural committees, and I think it's field because the hardest tool for the soft diplomatic and parliamentary diplomatics is culture, and I think we can move forward this discussion to this field like a culture sport or universities ties going to be heading this discussion. Thank you for 1 minute, much more.
Thank you. Thank you. We're going to extend the number of, say, questions and interventions before we return to our panel. So may I ask Mr. Frank Szczek to speak, but also to wave your hand so we as a panel there we see you. Hi.
Nice to see you again. We discussed yesterday the topic. I have 3 points. First point is that we discussed yesterday an informal part of parliamentary diplomacy happening during our gatherings, dinner, coffees, and also sometimes in the pub after such meetings. The second one, very important, is what I call a quasi-therapeutic one. You know, usually people said to us politicians, oh, yeah, you are all pigs and so on. We are not. We are trying our best, you know, and in this role. And the third very important one is that parliamentary diplomacy is one of the best ways, also as colleague before me is talking in culture and similar way, to passing away the stereotype and prejudice, you know. And I fully agree with colleague Humko that it's a Herzstück of parliamentary work, and I'm very keen into doing this. Thank you.
Thank you so much. We'll now turn to Mr. Chedimas Kirkilas. Can you please wave? Hi.
Thank you for the floor. This is a very interesting discussion, dear colleagues. At the moment, active parliamentary diplomacy is visible in the Eastern Partnership direction, that is in the Ukraine, Georgia, Moldova. Maybe in the future Belarus and Russia will join us at some point in time. But I would like to draw your attention to one important factor today. It is essential to strengthen inter-party relationship and diplomacy. And here I'm speaking about Belarusian Ukrainian party activities, because I think that today one of the weakest points in those new democracies is that they do not have strong party structures, which should be based on European values. Thank you.
Thank you so much. We now turn back to our panel. So, Mrs. Chigani.
Yes, I will start with the last point that was raised by the Lithuanian colleague on political party diplomacy. I think this is an extremely important point, and everyone who has been belonging to political party groups in parliamentary assemblies or the European Parliament, we know how beneficial and important this work in party groups is, because these are these are the people whom we share our views with and viewpoints on several issues and various issues. And in this regard, I really think that our political party groups here in COSAC and also European Parliament, we should try to find sister parties in countries in the European Union neighborhood and really try to address them all the time. Would you become a part of Social Democrats or EPP group or ALDE group? Would you become a part? Because it is very important for those newer democracies or more unstable democracies to actually realize that this party structure is very important for building democracy, and this international affiliation and ability to relate to the values of international party groups is very, very important. And also the last point about the friendship groups, I find this instrument very useful, especially to gather information, because there you can read only that much in international press about what happens in domestic politics in other European Union member states. And when we meet, we really get very good and fresh updates. So I value this aspect very much myself. Thank you.
Thank you. Mr. Hunko?
Yes, perhaps I could just follow on from that. I think that parliamentary diplomacy is important, among other reasons, in order to establish a political formation, a political family. You want to create a political family, and it's no easy task. I can certainly say this from my own point of view, representing the European left. There's a group in the European Parliament, there's a party, there's a group in the Council of Europe, which is made up of lots of different national parties, and it is very difficult to develop a consistent political line. I'm sure that's true for all the other parties as well. I think it's very important, but it's no easy task. Just a second point I'd like to raise. To my mind, parliamentary diplomacy is more able than state diplomacy to note when things are starting to go wrong and to draw attention to them and to come up with ways of putting things right. Let me give you an example from my own experience. When facing the crisis in Greece, solving the crisis or failing to solve it, as you wish, back in 2011, a German delegation went to Greece, and we found that the bilateral relationship was very, very shaken up. We were able to communicate that further, and we were able to come up with projects at government level to respond to that. So we, if you like, were the sensors or the antennas. Irrespective of your point of view, whether you think the right things are being done or the wrong things, we were able to identify difficulties arising at this bilateral level of parliamentarians. I think that members of parliament can notice these things more quickly than governments.
Yes, thank you. Well, I think what Giovanni Mauro was saying was of interest. It was very interesting. There are countries such as the United States which send senators and members of Congress to certain countries in order to look into certain problems, and then this information is used by the government. But they're not exactly independent. I think those things can go together and complement one another. Now, you mentioned Taiwan. I don't think there's any MP of any respect who hasn't been to Taiwan. Obviously, Taiwan, it's in Taiwan's interest to have us there working together with them. So they're doing a very good diplomatic job. I'm not sure whether we are. Well, we've got a friendship with them, and that's all well and good. We in Spain eliminated friendship groups. Now, of course, there were economic constraints, which is the case for a number of European countries. We all have budget restrictions, but we replaced it with something which was much better regulated, with agendas. We had preliminary discussions on programs before we went to the meetings, for example, annual bilateral dialogue meetings. We feel this is much more productive. But above and beyond what the agenda says, really the main value of this type of activity, on the basis of my own personal experience, is that it gives us a chance to interact at a level which was very, very, very different from what you might have even here in COSAC. Parliamentarians from different countries can talk to each other. At the latest, between Italy and Spain, for example, I sat down with the Italian People's Party, Popular Party group, and I spoke to one of the Italians there. And I think the most brilliant person at that meeting was Enrico Leitan, who was another of the MPs there. We established a very good relationship, and he ended up being Prime Minister in Italy at one point. So these so-called parliamentary diplomatic processes help us to establish personal contacts amongst parliamentarians. And we hope that these will help us in the future. Governments and parliaments change over time. And we think that it's a good idea to be able to take advantage of this type of meeting.
Thank you. Now, we still have 12 minutes left, so time is running quickly. We still have a number of people wanting to take the floor. Mr. Dobra Dorin, if you can just wave. Yeah, thank you. Please.
Please let me begin with a joke. Us parliamentarians are under obligation to undertake diplomatic activity, which is why we have diplomatic passports. But today, I'm going to talk about an example of parliamentary diplomacy in our relationship with a sister country, the Republic of Moldova, which is in the Eastern Partnership of the European Union. As of 2010, Romania has a strategic partnership with Moldova in order to integrate it into the European Union. In 2012, we set up a common committee, a common parliamentary committee, in order to better integrate the country, the Republic of Moldova, into the European Union. Obviously, Romania is very interested in Moldova having a European future. And Moldova is very interested to enter a stable union, which is why it's important to have parliamentary diplomacy. Because we can use this diplomacy to help Moldova on its European path. And we have the advantage that we can be more direct than traditional diplomats. Thank you.
Thank you so much. We're now going to listen to Mr. Ignacio Sanchez. Can you? Yeah, please.
Gracias.
Thank you. Our colleague from Germany was saying that parliaments are not governments, and governments, of course, are not parliaments. But states are states. So the question is whether a state can have a single foreign policy which is consistent, regardless of the internal process through which the policy is established. Now, there's no problem in having differences within our parliaments on foreign policy, nor is it problematic if we are present in multilateral parliamentary bodies. The problem lies in bilateral parliamentary delegations. Now, for example, you may have a European member state, members of parliament visiting Crimea without the knowledge of the Ukraine government. So we mustn't just ignore this type of difficulty. These are very sensitive issues. So the whole question of promoting the foreign policy established by a government must be taken into account by the parliament. The parliament as an institution has to have the same policy as the state, even though an individual parliamentary group within the parliament may have distinct opinions and can certainly express these. But as a public institution, parliament, I think, needs to be consistent with the policy established by the state.
Thank you very much for pointing us back to this essential question of the relationship between parliament and government. Now, let's call for Mr. Kelvin Hopkins, please.
Thank you, Mr. Chairman. Diplomacy, obviously, absolutely vital between countries, between governments and parliaments. But these contacts must not just be cosy discussions between members of the international political class, the EU elite, who essentially agree with each other on just about everything. We must recognise that there are large differences in political views, both with and indeed ideologies, both within countries and between countries. The serious danger is that electorates are becoming more distant from their politicians and their governments, and that there is always a danger that this degree of alienation leads to right-wing populism. We're seeing some of that now. I think that is very dangerous. In Britain, until recently, we had Cameron, Clegg and Blair, all of whom essentially agreed with each other. I couldn't put, as we say, a cigarette paper between them. There was no difference in their politics at all. And yet there was a great difference in politics between the voters across the country. I speak as a left-wing socialist, and I object indeed to being described as the same as other politicians. I'm definitely not. I have specific views which are very different from others. But EU membership is one thing that has really divided us. But all the party leaders tended to agree with each other on that. And now we're seeing the electorate is taking a very, very different view, possibly to leave the European Union. We are seeing serious differences of view which have not until now really been represented by the parties. What I think democracy has to offer is a real reflection of what people want and need, and a real choice of philosophy, choice of politics, so that if electors don't like their government, they can replace them with another government. That is the safe way for democracy. If we don't have that kind of arrangement where politicians conspire with each other, essentially against the electorate, we will see the rise of dangerous politics, which I think will be very uncomfortable for us all.
Thank you so much. Let's go for Mr. Zoltán Tesszely. Can you... Where are you? Oh, please.
Thank you very much for the opportunity, Mr. Chair, distinguished ladies and gentlemen. I think it is very useful to have such an informal debate on the parliamentary diplomacy. Well, the Hungarian delegation supports the amendment which was submitted to the Polish Sejm concerning the Eastern Partnership and the parliamentary dimension of Eastern Partnership. This is Euronest, and the Polish amendment emphasizes the importance of Euronest. We would welcome a more active and more direct participation of national parliaments in the Euronest. We think that this would also strengthen the diplomatic relations with the Eastern Partnership countries. I trust that in spite of the fact that the Troika did not support the Polish amendment, it will be integrated into the final version of the contribution. Thank you very much for your attention.
Thank you. I think we have to turn back to our panelists because time is running very quickly. Mrs. Cigane.
Yes, just a very quick note on the comment our Romanian colleague made on the parliamentary diplomacy you are conducting vis-à-vis Moldova, which is your neighboring country and shares the same language. We do a lot of parliamentary diplomacy vis-à-vis Moldova also, and there was a very interesting exchange I personally had with a member of parliament from Moldova. Basically, his statement was, we are offering our love to the European Union, and the European Union comes back and starts examining our heart. And then it took a long time for me to explain that actually the state and health of your heart is in your own interest. So what the European Union is forcing you to do is for your own benefit. And then after some time and bringing in many examples from our own accession to the European Union, I think I convinced him. So this is a good example how we can conduct parliamentary diplomacy. I will stop there.
Thank you. Thank you so much. Mr. Hunko?
Ja, vielen Dank. Ich würde gerne...
Yes, thank you very much. I'd like to respond briefly to what we heard regarding Crimea. I do understand the argument that was put forward, saying that there is, of course, a risk that activity in individual parliaments might undermine the diplomatic efforts of individual governments. I'd like to set another idea on the other side of that, though, which is that we, as members of parliaments, should be in a position to investigate what's happening in regions which are in dispute in international terms. We should be able to go and have a look at what's happening without being called upon to say what is legally correct or whatever. For example, in 2014, I would have liked to go to Crimea back in March 2014 to have a look at this so-called referendum, to see it with my own eyes and form my own opinion. And de facto, that is not possible. I've never been to Crimea anyway, but I'd be very glad to go there now and see what things actually look like. For example, what are things like for the Tatars in Crimea? Because the information we're getting has always been filtered, and I don't want to find myself making a decision on sanctions or whatever else if it's only based on information that's been filtered by someone else before I see it. And it is simply not possible for me to get my own picture and gather information for myself. That's not only the case for members of parliament, of course, it's the case for a lot of journalists as well these days. This is a real problem. There are black holes in Europe, and we don't want to see that.
Mr. Moreno Palanques.
Yes. Well, the question of Moldova, I think, has been made clear. This type of relation between neighboring countries is very useful. And one is an EU member state and the other one is a candidate. Sometimes it's easier to explain certain concepts from the inside rather than from the outside. So that kind of mission, I think, is very useful for parliaments to carry out, and we are trying to be helpful in these cases. My colleague from Spain was saying, Mr. Sanchez, that is, was saying that there should be policy. This is a very serious matter. There does have to be a policy in our countries, but the problem is that there are too many actors and we're all playing at diplomacy. And so there can be a conflict and we end up achieving nothing. A state may be trying to do something well at international level or at the European level of the European Union, for example, and we can contribute to achieving the best possible result in our diplomatic efforts. But, and I'm not saying the Crimea is a case or it's not, but I'm just saying that if you have lots of actors going around engaging in diplomacy, it doesn't always work. These conflicts go on and on and on. If you have a neutral visit, which is not planning to issue any report, can nonetheless be used by one party against another. So with all due respect, I think we should be careful about having this idea of having a single policy in each state. Now, I'm not going to talk about Brexit because nobody's been talking about Brexit. References have been made to the British Conservative Party. Well, I think that a referendum such as the one that's going to be held, well, we'll see what happens. I think if the UK leaves Europe, we'll all be damaged. Some in the UK would say no. We'll have to wait and see. But I would like to say that governments are elected in the European Union. Yes, I'm finishing up, moderator. Governments are elected. Parliaments are elected to represent the citizens. Now, if whenever a government has to take a decision, or whenever a parliament has to take a decision, it has to be submitted to referendum, and this is what we're basically seeing in my country with some of the new political formations, not to mention any names. And basically, what's happening is all of the decisions are based on referendum and local caucuses. You can't govern that way. So governments and parliaments have to have their prerogatives.
Thank you. Dear colleagues, and I think we have to end here. Our time is up. There were still at least 6 people on our list, but I hope we can continue those dialogues in a more informal, bilateral kind of format. I think I'm very grateful for this discussion with you, because me as an academic, I've been able to get out of my ivory tower and to see how indeed diplomatic, and parliamentary diplomacy takes place in practice. I think we learned a great deal from all the interventions. Really, we shared a lot of positive experiences, that's great, but we also deepened our insight in the many challenges that remain. So I'm grateful for our excellent panel members for their very open interactions with all of us. I'm very grateful to you for your questions and remarks. There are no further conclusions générales, because that would be taking us far too far. I'm going to now simply hand over again to our chair and host, Mr. Elzinga. Thank you very much.
Thank you very much, Mr. Wouters. Thank you very much, all 3 panelists, for your very interesting panel discussion, but also for the lively debate that we had here in the plenary. Finishing this session, we have also come to the end of the plenary meeting of today. Those of you who are not acting heads of delegations may leave now. There are buses, or you may walk to your hotels, and we look very much forward to seeing you again at tonight's social event. The acting heads of delegations will remain here in the Hall of Knights for our meeting on the final draft contributions. I wish those leaving a good afternoon, and I would like to remind you that the buses to our dinner venue depart at 7 p.m. from the conference hotels. In order for those leaving to be able to do so, I will suspend this meeting briefly, only 2 minutes, but please, heads of delegation, remain seated. Okay, bye for the rest. See you tonight.
All right, let's start. Dear colleagues, welcome to this meeting of the COSAC chairpersons. The goal of this meeting is to exchange thoughts on the proposed final draft contribution that were presented by the Troika. We strive for consensus on the outcomes of this COSAC meeting. Perhaps the following discussion could aid this goal. As my colleague Mr. Elsinga has explained this morning, the proposed text for the contributions has been updated yesterday by the Troika, taking into account the previous submitted amendments. This resulted in a final draft document that we would like to discuss in this meeting. All delegations have received a table which contains the original text, the previous amendments submitted by delegations to the first draft contributions, the compromise text, the final draft, as suggested by the Troika, and any new submitted amendments. We will handle the contributions per page. The text proposed by the Troika is shown on the main screen and on your multimedia device. Our aim is to reach consensus, and our compromise text is drafted with that focus. If you would like to take the floor regarding a certain compromise text or amendment, please indicate so on your multimedia device. Once I give the floor to you, you will get the chance to very briefly explain your amendment. My colleague, Tuur Elsinga, will then very briefly explain the Troika compromise or the reason the amendment is not adopted by the Troika. At this point, I will see if there is consensus to adopt the compromise, or if there is no compromise text, consensus can be reached on the original presidency text. If no consensus can be reached, we will conduct a vote. In case of a Troika compromise, we first vote on the Troika compromise. If the compromise is officially adopted, the new amendment is denied. If the Troika compromise is denied, or if the presidency text is maintained, we will vote on the new amendment. If the new amendment is adopted, it will be part of the contributions. If the new amendment is denied, the original contribution as was written by the presidency, or in case of a Troika compromise, the Troika compromise text is automatically adopted. The voting rules are explained in Chapter 7 of the Rules of Procedure of the COSAC. Contribution shall be adopted with a qualified majority of at least 3/4 of the votes cast. The majority of 3/4 of the votes cast must at the same time constitute at least half of all votes that could be cast, being at least 29 votes in favor. Furthermore, each delegation of an EU member state and of the European Parliament has 2 votes. That means that there is a maximum number of 58 votes. However, the delegations of Cyprus, Denmark and Ireland are unfortunately not present. That means that this COSAC meeting has a maximum number of 52 votes. Each head of the delegation has the ability to vote. Our voting system is programmed in such a way that also unicameral delegations will have 2 votes. These are awarded to the head of the delegation. These votes are registered by pressing the button only once. The screen behind me and your multimedia device will now display how the votes have been divided over your delegation. Please note that it is not possible to change these voting rights to other members of your delegation. If another member of the delegation should have the right to vote, please change the seats. You will only have 2 options during the vote. You will either vote in favor or against. In favor indicates that you are in favor of adopting the Troika compromise or amendment that is shown. Against indicates that you are against adopting the compromise or amendment that is shown on the screen. Again, we will always voting in the following order. The Troika compromise, if there's one, and if needed be, or if there is no Troika compromise, the new amendment as formulated by a delegation. If neither are adopted, the original contribution as drafted by the Presidency is automatically adopted without an additional vote. You will have 20 seconds to vote, and the result is displayed on the main screen and on your multimedia device. I assume the voting process is now clear. I would like to stress the fact that the Troika compromise have been especially drafted to achieve consensus without conducting numerous voting procedures. Now, let us move on. All right. If we see to the final draft contributions, I presume, because there is now 8 amendments left, there were previous amendments were 39, and now there are 8 amendments left. And I presume that there will be some remarks about the contributions. Then I want to begin first with page 1 of the English text of the final draft. That is 1.1 up to and including 1.4. There's one amendment from a French Senate, and the amendment adds the word to take into account. And our Presidency suggests to accept this new amendment of the French Senate. Is there objections? No? Then we can say that we agree on this specific amendment. 1.2, 1.3, 1.4 on page 1 of the final draft contribution, there was no amendment. I believe there's consensus on this. Yes. Then we agree on. Then we go into 1.5, the second page. This is 1.5 until to including 3.3 on the French contributions. It's on the next page, 3.3 on point 3. There's no amendments on this. I believe there is consensus. Yes, we can agree. Thank you very much. Then we go into page 3. That is in the English version 3.4 until 6.1 including. That is on the French side. French version is that the next page. Also, there is no amendment submitted. But I believe there is consensus on it, no objections, then we can approve. Then can we go to page 4 of the contributions, and there are a few amendments. It's on 6.4 of the draft, there are 2 amendments. An amendment of the European Parliament and also an amendment of the Poland Senate and Sejm and Hungary. Is there anyone who would like to take the floor to make a remark about that? No? Okay, our advice for the Troika is to just to not accept that proposal, the amendment of the EP and the amendment of Poland and Hungary. But maybe there is, yes, I see one. Ms. Hübner from the European Parliament. Ms. Hübner, may I give you the floor?
Yeah, okay, it's read. I just would like to inform you that the Parliament would like to maintain the proposal of yesterday, so that we not just talk only about dialogue, but also about the enforcement mechanism. And yesterday we couldn't reach the agreement on this, but we have maintained this amendment.
That's clear. Thank you very much, Ms. Hübner. Maybe there's also from the Polish or Hungary, they have an opposite amendment because they suppose that they want to take note and only develop existing dialogue as an opposed amendment and the amendment of the European Parliament. Is there someone? Maybe I see Sir Mr. Obremski from Poland.
First of all, we are against the proposal of European parliaments, and we want to look for the more soft solution, the point 6.4, and take the words supports who takes no of. And please support our amendment.
Then I see also that Sir Wilmicke wants to have the floor. May I give you the floor?
Thank you very much indeed. 3 or 4 short points. First of all, it is for national parliaments to set the laws for their member states. Secondly, the European Union is not a human rights body as such. Thirdly, there is no consensus on what the words common values mean in the treaties. And finally, COSAC, in my judgment, should not sign up to something which enlarges EU competence. So those are the 4 points and the reasons why I would resist the European parliamentary proposals. It's based on the principle of enforcement of the rule of law. I'm neutral on the Polish-Hungarian one.
Thank you very much for your remarks, Sir Cash. Then I want to give the floor to Ms. Lolita Tsigan from Latvia.
Yes, thank you very much. I would like to support the amendment as submitted by the European Parliament, because I believe that we are still talking about being a union of values, and this is very important. We are not really talking about concrete mechanisms, but still, if things are not enforced, then sometimes in practice they stop existing. I think that it's a balanced and a good suggestion. Thank you.
Okay, thank you very much, Ms. Tsigan. Then I see that Richard Herzig from Hungary wants also to have the floor. Mr. Herzig.
Mr. Chairman. So we would like to have our amendment with the Polish Sejm that we do not support the European Parliament's amendment. So we would like to see that takes note would be instead of support. If our amendment will not accept, we would like to stay at the original text 6.4.
Thank you very much, Mr. Herzig. Then I see a request for the floor for Ms. Hübner. Is that correct?
Yes. Thank you very much. I would like to propose a compromise version of the Parliament's proposal. We think that we could have, instead of enforcement, we could say and compliance mechanism, or we would be also open to the wording that would be the following one: mechanism upholding the values of Article 2 of the Treaty of European Union. If there is a need, because Mr. Kash, I think, mentioned that there is nothing like common values of the European Union, I completely disagree with him, but we are prepared to say that we are talking about the values which are referred to in Article 2 of the Treaty on European Union. So we could have compliance or mechanism upholding the values of Article 2 of the European Treaty on European Union. So compliance or upholding mechanism, and instead of common values, values as referred to, or the values of Article 2 of the Treaty of European Union.
Thank you very much, Ms. Hübner. Then I want to ask Mr. Elsinga, may I ask you to shortly explain the reason why we say, as also different in the Troika, but we don't support both amendments?
I will try to. I think it's clear that there is unfortunately no consensus on the amendment of the European Parliament. It gets support from Latvia, but it also gets rejection from the UK Parliament and from the Polish delegation. The Polish amendment wants to go exactly the other way around, wants to soften the language instead of make it tougher. And that's why we think that the best consensus should be to stay with the text that we had as a presidency suggested, and just reject both amendments. That would be our compromise solution. Let's see if we can avoid the vote.
Yes, thank you very much, Mr. Elsinga. I'm looking also to the floor. Can we adopt the presidency proposal by consensus? No, I see no. Then we start to a vote. Unfortunately, but I can understand that. Then we vote on the first amendment. That's the amendment from the European Parliament. All right. We will now put the amendment of the AP as shown on the main screen, if it's possible, to a vote. Yes, we are going to vote.
Right, you have 20 seconds.
All right. Yeah. The text is over there. Vote in favor if you are in favor of the amendment by the European Parliament that is proposed. Ja. Vote against if you are against the amendment.
Ja, Duur ook gestemd? Ja.
Duur. You have now 20 seconds to vote. In favor or against? And I believe... Yes. The voting is your amendment from the European Parliament. There is no consensus in this session. People want to vote. Then I have first the amendment of the European Parliament brings in the vote. And you can choose in favor, I presume. All right. The vote is closed. Then I see the total vote cost is 48. No, there is no enough in favor. That means that the amendment of the European Parliament is not adopted, unfortunately. Then we going to vote the amendment of Poland and Hungary. May I have your vote, please? The proposal of the amendment of Hungary and Poland.
To reject both.
No, we're going first the amendments. Yeah.
Je moet stemmen, denk ik.
Yeah. There we are. Thank you for your votes. A total votes cast of 46, 11 is in favor, 35 is against, and that means that the amendment has been rejected, and it means that we stay with the presidency proposal.
Percentage? Waar is het percentage te laag?
Dat weet ik. 29. Yes, yeah, Ms. Hübner. Ms. Hübner, I can give you the floor.
Yes, thank you very much. That's why I was raising at the beginning my hand, because I wanted to understand what is the order of voting. Because we have proposed also the changes to the amendment, to replace the enforcement with compliance mechanism. So I understood that you will be proposing some order of changes, but you refused to vote what we proposed as correction of the amendment.
I see also to my colleagues from Hungary and Poland, and I see that they don't want to have a compromise on this specific issue. Then I say also, then we bring the amendments into vote, and that's the result of the voting. that both amendments are rejected, unfortunately, for you. Yes? Then we move on. Yeah. I want to give the floor to Ms. Hübner, yes?
I just would like to remind you that we couldn't find on your proposal the agreement among Troika, and that's why the whole thing has started. So just that we are all happy that the procedure was correctly getting us through, we probably should vote also the proposal that you have put on the table, because we disagreed with your proposal. Yes, so can we vote also your proposal, and then we will be on the safe side, I think, from the procedure point of view.
Yes, but Ms. Hübner, there was no possible that we can reach a compromise because the different delegations have different opinions on this specific issue. That's the reason why I bring it also in vote. And I want also to give the floor now to Mr. Hussey to hear his opinion.
Thank you, the floor, Mr. Chairman. So I would like to come back to this original amendment. We suggested that takes note should be instead of establish, instead of support. If this amendment will not accept, I would like to give an oral amendment, an additional text that at the same time the COSAC acknowledges certain Parliament reservations regarding the establishment of new mechanism. So the original text, says that COSAC supports initiative, and we put an amendment instead of support takes note.
Is this a compromise?
Thank you very much.
Would it be
for
possible
your
in the
remarks.
compromise text?
I can understand that for European Parliament it's difficult to say to note that and that they prefer support, but I want to give first the word also to Mr. Kirchbaum.
Thank you very much, Chairman. Yes, I think we've just voted, and once a vote has been cast, then, in accordance with our rules of procedure, we are supposed to move on further in the document. Otherwise, we'll never get to the end. So may I please call upon all the colleagues in the room to stick to this principle. A majority has come in favor of the Troika proposal, and I think the time has come to move on. We've had our vote. Please, can we move on?
Thank you very much. Then we move on. All right, then we go to the next amendment. But we're going to the text. Where is it? That's on 6.9. There's the amendment from France. Oh yeah, I'm sorry, excuse. There's an amendment on 6.6. There's also an amendment of Poland and Hungary. It goes to delete, they propose to delete the word legislative. Is there someone who wants to take the floor? Yes, Mr. Herzig.
Thank you, the floor, Mr. Chairman. So my explanation is that interinstitutional agreements, as defined by Article 265 TFUE, aim at laying down arrangements facilitating the cooperation of European Union institutions and its member states. Interinstitutional agreements cannot impose obligation on member states. Thank you.
Thank you very much. Is someone else who wants on this issue? No? Then I go to... May I ask Turelzika? Yeah? Well?
Just a second.
Changes very much in agreement with my colleague Krishpan, but I have had a green light on for some time, but I've been unable to extinguish it. I'm not sure whether it can be turned off now because I have nothing further to add.
Thank you very much, Mr. Boswell. Yeah? Ms. Hübner, you want to add something about this amendment to delete?
Yes, I would like to, first of all, to inform you, because you didn't give me the floor, that we keep the reservation with regard to the previous vote, because there was no agreement in Troika, and then you didn't allow me to get the vote from you, so we just keep the reservation. We will do it in written. Here we would like to propose that if you cannot live with legislative, which is the European Parliament language on this type of the reports, I would like to propose that we just call this own initiative report, Article 225 own initiative report, because this is a very special procedure when the European Parliament requests from the European Commission a certain action, and then if we can't have it with its name, which is legislative, then we just would like to get it from the treaty, which is 225 article report. Thank you.
All right, thank you very much, Ms. Hübner. Can I also ask Tuur Elsinga on behalf of the presidency?
We have not discussed this in the Troika. First of all, because it was a new amendment, we already were informed that the European Parliament didn't want to scratch the legislative, but now there is a compromise suggestion I hear, so maybe it would be good to see if that's also acceptable for Poland, to replace the word legislative with Article 225, because then I think we can have a compromise.
I think we have reached a compromise. Thank you very much for your good work on this issue. We have a consensus. Yes? All right. Then we are going to 6.9. There's an amendment of the Assemblée Nationale Française. Madame Auroy, may I give you the floor?
Merci.
Thank you. Yes, very quickly, we wanted to propose replacing the term human rights, which is in French sexist because it's the rights of man. We would like it to say droit humain in French, and talk about democratic governance as well, because that helps us to make more precise statements on this subject. So in English it would be human rights, in French it would be droit humain. And then on the green card, that was an example to remind you that the green card is something that's developing. It was an example of my previous point when I was talking about human rights. I just wanted to alert you to this. I could give up that part of the amendment if human rights are included in the text. Thank you.
Merci, Madame Auroy. Mr. Tuur Elsinga, may I ask you to shortly explain the Troika? There's no Troika compromise, but why the Troika suggests not accept this amendment?
On the first one, I think that we did accept in the compromise, or in the new text, I think it was accepted. On the green card, within the Troika, we discussed this amendment as well, and we decided not to accept it, because however sympathetic the idea is that the presidency adheres to the Troika final draft with a focus on the role of parliaments with regard to the rule of law. That is the whole focus of this chapter, this paragraph. And secondly, the proposal is of course dealt with in a very sympathetic green card procedure, which has been sent to all parliaments to either support or not, but to discuss. So I think that's where it should be dealt with, and this is why we suggest not to take it on board.
Yes. Can I see there is consensus on the presidency proposal? Yes. Thank you very much, Madame Auroy. Then we move on to the next page on the contributions. The 7.1. There's an amendment from Spain, Senate and also deputies. And they have an amendment where they add something on 7.1. Is there someone who wants to give from the Spanish delegation? Yes. Mr. Moreno, I believe.
Thank you, Chairman. The idea was to cover something we were discussing earlier. In any case, we don't want to lengthen our discussion now if there's no consensus, so we'll leave it in the hands of the presidency. You can decide whether to present this or withdraw it, depending on what you think the situation is.
Thank you very much for Mr. Moreno for your contribution, and I see also to my colleague, Ture Elsinga.
Someone else did request.
Also, Sir Cash, do you want also have the floor? No. Is there consensus on the presidential text? Yeah.
We suggested as a presidency not to accept the amendment from Spain because we feel that this amendment is a little bit too much telling national parliaments what to do. It says shoot 2 times and we think it is up to the national parliaments themselves whether to coordinate or not with their governments and whether to coordinate or not with the European institutions in the future. So we suggest not to accept this.
Okay, thank you very much. Mr. Elsinga, I believe that the Spanish delegation says also that it's on our hands, because there's consensus to stick with the presidential text. Thank you very much. We move on to the next amendment. This is the amendment of 7.6 on the next page. And it goes about that an amendment of Poland and Hungary, and they propose that COSAC underlines the important role of the Euronest, plays cooperation with parliaments of the Eastern Partnership countries as a part of EAP multilateral framework. COSAC hopes for active engagement of all its members in this regard. Who may I give the floor on this specific amendment? Mr. Klocz from Poland.
Dziękuję. Szanowni Państwo.
Thank you, ladies and gentlemen. I think that this element of Eastern Partnership should be taken into account in our actions. Until now, we didn't have any concrete statement in the COSAC conclusions about that element. Meanwhile, Euronest is the association of the members of the European Parliament and parliaments of the Eastern Partnership countries, and I think we do need such enhanced cooperation so that this part of Europe is also taken into account in our activities.
Thank you very much, Ms. Klok. Maybe I can give Ture Elsinga the floor about this specific amendment.
We discussed it yesterday in the Troika, and we suggested not to accept it. But after you have retabled the amendment, we had a short consultation of the Troika members, and we now think that we can consider to take it on board. So we suggest to, if there is no objection and we can have consensus, then it's fine with us.
Okay, thank you very much, Mr. Elsinga. I believe Ms. Hübner.
Because I don't know how to show really that I want to say something, because you don't react to the to the lights. I just wanted to support this amendment because in the European Parliament we very clearly see that Euronest does not work well. So if we can give this support, that would be probably very useful. Thank you.
May I give the floor to Günter Gierkbaum?
When it works, yes. Thank you, Mr. Chairman. I would also underline the importance of Euronest, but I have a special request. We should also keep in our framework. That means that we should only put in the conclusions or contributions these issues which were discussed in the framework of COSAC. So that means we did not have a debate about Euronest, and but the importance there's no doubt about it. But anyway, perhaps for the future we should keep also in our procedural laws. Thank you.
Thank you very much, Mr. Kriegbaum, for the advice, also for the next presidencies. Is there anyone else? Yes, I see Ms. Sigan from Latvia.
Yes, I would also like to support this amendment because indeed it is so that this specific issue was not specifically discussed, but still discussing the parliamentary diplomacy issues, many of the members who contributed, they actually mentioned the importance of work with the parliaments of countries that neighbor the European Union, including also the Eastern Partnership countries. So I would like to support the Polish colleagues' amendment.
Thank you very much. Then I see also a question for the floor for Ms. Bastos from Portugal. Ms. Bastos.
Thank you. I just wanted to confirm and support the position expressed by our German colleague. I'd like to say that we should not have this amendment in the contribution because it's something that was not discussed.
Right. I heard Mr. Kriegbaum that he says for the next presidencies, then it's, we must be strict at the procedures. But I believe that I've heard the words of Mr. Kriegbaum that now he can accept it. Then, Madame Auroy, you ask also for the floor. Madame Auroy, may I give you the floor?
Thank you, Chairman. I'd like to emphasize, following up on the other colleagues, Mr. Kirschbaum, I agree that we're working on the Eastern Partnership, but we have the whole Mediterranean issue. Are we going to leave some of these points outstanding? I think it would be more balanced if we include the Mediterranean. After all, the migration issues are related to the Mediterranean, and then we have issues related to partnership, which take place in the context of the Mediterranean as well. So I think if we only talk about Euronest, it's a bit restrictive.
Thank you very much, Madame Auroy and Mr. Blaha.
Thank you very much. I would love to confirm that as a next presidency, we are not going to take this as a precedent. So if we are not directly open the discussion about something like this, then it will be cannot be in the presidency conclusions. But for now, I think we can agree on this. But it is not a precedent. This is very important.
Is there, I believe, not by everyone is a consensus to accept this amendment? All right, then unfortunately I must bring the amendment of Poland. Yes, Ms. Sigan, maybe you help?
Yes. Regarding the question whether the southern neighborhood is reflected, I would like to thank the presidency and also Troika for supporting our amendment to 7.2, where we exactly specify what we mean by the EU partnerships with neighboring countries, where we say with both eastern and southern neighboring countries. I think this should resolve because both regions are reflected as equally important in this amendment.
Thank you very much, Mr. Gahn.
gaat misschien om.
Yeah. Then I looking only to the colleagues from Portugal. No, they don't want to accept. Then I must unfortunately bring the amendment from Poland and Hungary in vote. All right, then we are going to vote.
Stemming over 30 seconden, jij moet stemmen.
May I have your vote, please? In favor for amendment of Poland or against? Nee, heb ik al gedaan. Thank you for your votes, and I see that unfortunately for Poland is refused the amendment.
Vanwege het aantal.
Because in favor is 28 and we need a threshold, a minimum from 29 votes, the half of the votes, like the procedure in Article 7. I'm so sorry. Yes? Then we go to the next. That's the amendment, and that's the amendment from Italy. And it suggested a new chapter, Chapter 8, about migration. Is there someone who wants to speak on behalf of Italy? Yes. This Mr. Tancredi, may I give you the floor?
Sì, grazie.
Thank you. Well, first of all, we're quite determined, we feel quite strongly about the text of this amendment since we've given up on a number of other points where the Troika didn't agree with our proposals. On the question of migration or immigration, this is something which is on COSAC's agenda. Now, the text that we've submitted is very general. On the agenda, we specify the agreement with Turkey, but what we have in our amendment are points that have already been broadly supported by the majority of the European institutions and the majority of the member states. So we don't see any reason why this would be rejected, and we have a very firm stance on this.
Thank you very much, Mr. Tancredi. Then we are going to Mr. Kourakas from Greece. He asks also the floor.
Chairperson, I think that the Italian amendment is correct. The question of migration flows is in the agenda. We cannot simply move out of this room without any reference to this issue. And apart from the position of the expressed position on the need for solidarity, there is here a tendency for a positive view. In other words, the possibility of supporting countries from where migrants originate by helping their economy. There is one slight point where we're not fully in agreement. It refers to, the text refers to countries of Africa. We could include Asia or the Middle East because a number of major part of the migrant flows come from Iraq and Afghanistan, or we could simply drop this, but this is not important for us. But I don't think that COSAC should accept this paragraph, because without it the document will be less than adequate. Thank you.
Thank you very much, Mr. Kourakis. Then I think that it's good that maybe also Thur Elsinga explains on behalf also of the Troika why we don't accept this amendment from Italy. Yes, I see the floor. But maybe it's a good idea that we ask first what's the reason why the presidency and also the Troika don't accept this amendment. Mr. Trielska, may I give you the floor?
Thank you very much, Chairman. However important the topic, the presidency suggests to discuss this topic tomorrow seriously, but we have also reasons to not support this amendment, and we have 5 of them. First, there were conclusions on the issue adopted during the 54th Plenary COSAC in Luxembourg, but also at the Interparliamentary Conference on a common foreign and security policy under the Dutch presidency, and on the occasion of the Conference of Speakers in May in Luxembourg. Secondly, we did not include this subject after that we had conclusions in Luxembourg again in our questionnaire, so they are also not part of our biannual report. Third, we have not had yet the chance to discuss this topic in this COSAC meeting of migration today. It will be on the agenda for tomorrow. Fourth, many aspects of this policy and legislative proposals are still in development. And finally, it seems quite unlikely, we feel, that we will be able to reach consensus on this issue today. That's why in the Troika meeting yesterday, we did not accept it, and when it was tabled again, as the presidency, we looked on the issue and we still have the same 5 arguments not to advise in favor of this amendment.
Thank you very much, Mr. Elzega. There's a list of speakers now. They asked the floor. May I give first of all the floor to Mr. Kopp from Austria.
Well, Chairman, ladies and gentlemen, Austria is a country which has been very much impacted by these questions in recent months, and we support Italy's proposal. We think that it includes some very substantive proposals for improving the situation, in moving towards joint action and more solidarity, and also regarding changing European legislation along those lines. So we support Italy very much here. And Chairman, I think that the arguments that have been put forward are in many cases more procedural points, more things which have often been dealt with in the past. However, I think we haven't had really convincing arguments against the Italian position. Sorry to be blunt.
Okay, thank you very much, Mr. Kopp. Then I want to go to Mr. Bisset from France, from the Senate.
Merci, Monsieur le Président.
Thank you, Chairman. Well, I think when it comes to migratory flows, possibly or probably it's the most important topic we're dealing with at this COSAC meeting. So I'm very much in favor of this amendment, because treating the underlying causes of migrant flows and all migrant issues is important. We've got to get to the bottom of things, and Italy is very much involved, as we know. What I would say to our Italian friends is one thing I'm not quite so happy with is the resettlement program for asylum seekers, because this policy has not yet been completely done and dusted. It's still in development. So I think we could take the Italian amendment and delete the reference to relocation, resettlement. I think in that case it would be perfect. I will certainly vote in favor of it anyway, because I think Italy is really giving this problem all it's got.
Thank you very much, Mr. Bisset. Then I saw the call for the floor to Mr. Busuttil from Malta.
Grazie.
Thank you, Mr. Chair. On Malta's part, we can say that we are truly in favor of this amendment. Malta together with Italy, but it is truly Italy that is bearing the brunt of this irregular migratory flow from Northern Africa. Several people are still dying, thousands of them in the Mediterranean. I believe that this is still truly topical as an issue. And during this COSAC meeting, we'll be discussing this migratory flow, which is why we should have this paragraph with this amendment. I have no problem with the amendment introduced by Greece, which would expand the migratory flow to also to that which is coming from Asia as well. But we believe that immigration is truly an important topic and deserves our support. It is not simply a problem for the Mediterranean, for Malta or Italy. It is a problem of the whole continent. Thank you.
Thank you very much. As a chair, I want to say that I think it's not good to have a fully debate on the migration issue today. We have tomorrow we discussed about the EU and Turkey agreement, but I know what the sentences are, and I believe also there are different views in the different member states of the European Union. But we must concentrate on this amendment. And I heard also Ture Elsinga says there are also procedural reasons why you can't accept this maybe in these contributions now. And I ask also for the next speakers maybe to address something about the specific procedural issues. Sir William McCash, you asked also the floor.
Thank you very much, Chairman. Just to say, I very much rather agree with what you've just said. And the House of Commons European Scrutiny Committee is acutely aware of the pressure on our Italian friends and those in the frontline states. And we as a committee have often pressed our government to fulfill its promises to help. But unfortunately, as you know, there is very little known about how the Dublin regulation is going to be recast, re-established. And really, we're not in a position, in the light of that, to be able to support this part of the amendment. And in any case, the United Kingdom doesn't support relocation. Basically, we wouldn't want to go along with it. Thank you very much.
Thank you, Sir Pesch. Then I want to give the floor to Mr. Kriegbaum from Germany.
Vielen Dank, Herr Vorsitzender.
Thank you very much, Chairman. Well, Chairman, as you said, we should be getting to grips with procedural matters and ideas. I think from the German side of things, we support Italy's proposal entirely, including the point raised by Greece and others. Now, the Troika started off by saying, yes, everything has already been said and it needn't be repeated, if I could summarize your position in that way. Now, this is the most important topic ever. It's by far the most important topic, without getting involved in substantive questions. And COSAC should be saying something about the subject. It is on the agenda, and it's the second point that you raised. It's only on the agenda for tomorrow, but if we're only going to be talking about it tomorrow, and our conclusions and topics won't be saying anything about it, then today's discussions should take place tomorrow as well, once the debates have been discussed. I think that I think this is this. I've been to a great many COSAC meetings, and I never had an event like this happening before. If a topic is on the agenda, then we can and indeed should say something about the subject. The third point that your side of things made was that it was a matter of the questionnaire. I'm sorry, but that is irrelevant. It's irrelevant whether it's a questionnaire topic or not. The point that decides it is whether it's an issue on our agenda. If it's on our agenda, then our conclusions and contributions can say something about it. And I repeat, not only can, but should say something about it. Then your last point was that it might not be possible to reach a compromise this evening. Well, yes, that's completely true. There's always that risk. But that's why we have the final decision-making at the end and the vote. So therefore, I think the reasons you put forward, to my mind, from my point of view, none of the reasons you put forward stand up. I therefore think if we want to make this into a topic for the agenda, then it should be in the contributions and the conclusions. We should say something about it. And I repeat, this is by far the most important topic facing us today, and therefore it is essential for COSAC not to be silent on the subject. Thank you.
Thank you very much. Then I go to Ms. Auroy. You ask also the floor.
Oui, merci, Monsieur le Président.
Yes, thank you, Chairman. I can be very brief, following from what my friend Mr. Kirschbaum said. I agree fully with what he said. And Jean Bizet, I agree with as well. The French National Assembly fully supports Italy's proposal.
Then Mr. Romano asks the floor from Italy.
Thank you. Thank you, Chairman. A very brief comment. We welcome the proposal for an amendment from Greece. We accept the change by France, as Jean Bizet was saying. We feel that nonetheless this amendment should be put to a vote. And finally, tomorrow is devoted to migration in our agenda. So perhaps the whole document we're discussing this evening should be postponed until tomorrow after the session on migration, or the question of migration itself could be subject to a vote. Otherwise, it's a procedural difficulty. It wouldn't be logical.
Thank you very much. Then we go to Mr. Senisek from Czech Republic.
Yeah. Okay. Thank you, Chair. Dear colleagues, I would like to point to one technical, I think, problem with the last paragraph and the second half of it. Seems that it refers to the proposals presented by the Commission on May 4th. But the problem with them is that they have not been, in 6 weeks since then, translated to the national languages, and they are not going to be translated for some more weeks as our information goes. So the national parliaments didn't have a chance to actually discuss these proposals formally in their proceedings. So I think it's not very fair to our colleagues back home in our parliaments to say that this needs to be very quickly implemented when we didn't have a chance to actually formally discuss it. Obviously, maybe what is meant, I don't know, what is made are the already valid decisions of the Council about the relocations, and there is no doubt about that, and there is no problem with that in my eyes. But if it's the May 4th proposals by the committee, I think this is a little bit of a problem, and maybe this part of the amendment might be voted separately. Thank you.
Thank you very much, Mr. Senisek. Then we're going to Ms. Granlund from Sweden. One moment, please.
Ja, kan je die nu aandoen? Nee, ze staat nu weer gevonden. Granlund. Even die ernaast. Dank je.
Tack för det. Från svensk sida.
Thank you. Well, Sweden supports the Italian proposed amendment. There's nothing odd about this. The European Council has already more or less decided on this. It's been a long time since we met in Luxembourg. We are facing a humanitarian disaster, and we need to show solidarity both with other countries but within the Union too. We need to act, and I think it would be very odd if COSAC did not express a position on the greatest question in modern times, and that is why we would support the Italian proposal, and of course the redistribution mechanism should remain in place. It is central.
Then we go to Mr. Hercik from Hungary. Mr. Hercik.
Thank you, Mr. Chairman. We would like to support very much Monsieur Bizet's the French Senate new amendments, namely that we should leave the second paragraph starting with COSAC recognizes and so on and so on. And finally, I would suggest and support very much Mr. Hampel, the Czech Senate amendment. The last paragraph, not acceptable, but I would like to put one word instead of the endorses, putting a new word, take note. Thank you.
Thank you very much, Mr. Jurczyk. Then we're going to Mr. Boswell from United Kingdom. Sir Boswell.
Thank you, Chair. I listened to this debate very carefully, and I sense that we need to be moving towards a conclusion. What is clear to me is that there is a serious problem for our countries facing the direct impact of migration, and there is a need for a long-term strategic approach to this. I think that discussion has got confused or conflated with the immediate but important measures which are under discussion. Some of those, including, for example, the recast of the Dublin regulation, have only very recently been promulgated and are under discussion. I don't think we should mimic the decisions of the Council of Ministers. I think we should try and leave those specifics out. And my proposal would be substantially to conclude the amendment with the words unprecedented flow of refugees and migrants, and to delete the more specific suggestions after that. But if that were done, then I would feel able to support the amendment.
Thank you very much, Lord Boswell. Then we're going to Mr. Schenach from Austria.
Dankeschön. Thank you very much. We support Italy's proposal here very strongly as it stands without alteration. I think that it is generally known what is currently being debated across the whole EU. And COSAC is going on till tomorrow. I've been for COSAC, coming to COSAC year after year, and I think the formal argument that we're not discussing this until tomorrow, it doesn't stand up. I think if we're going to do that, we'd have to delete our last 10 years of work. We've always come up with a document covering all of our meeting. I think that this is a tragic situation that we face, and I think that the Italian paragraph should be inserted as it stands. And please, when it comes to the choice of words, please, could we not talk about countries which are on the front? The front is in military term, and we are dealing here with a humanitarian issue. Thank you.
Thank you very much. Then I go to Ms. Bastos from Portugal. Ms. Bastos, you have the floor.
Thank you. The Portuguese delegation has no reservations and fully supports the proposal by the Italian delegation as drafted and in whatever form it is accepted.
Thank you very much. Then we go to Mr. Blaha from Slovakia.
Thank you very much. I very much appreciate the Dutch arguments, because I really think that this body is discussion body. We should exchange our arguments, and I think there is no necessity to overvote somebody if somebody thinks that he is true. And if this body should be like this kind of majority principle body, okay, this is not COSAC principle, I think. COSAC principle is about the discussion and debates. Everybody knows that Slovakia cannot vote for the relocation of asylum seekers. It's our serious political problem, together with Hungary, together with Poland, together with the Czech Republic and Great Britain, I think. So that's why everybody knows what's the mathematics and, about this voting. We have probably the blocking minority, so yes, we can vote. But I really don't understand why we should repeat the Luxembourg precedents. It was the situation in Luxembourg. Is it really necessity? Because I think it's insulting for the common sense of us, because everybody knows what's the situation. So that's why I really appreciated Dutch diplomacy, that you don't want to open the problem, but you want to discuss the problem. And that is something which we will continue and follow also in Slovak presidency, because otherwise we can quarrel forever, and in the end we can overvote somebody. This is not the principle of COSAC, I think. Thank you.
Thank you very much. Then we go to Mr. Shaker from Slovenia.
Thank you, Chairman. Slovenia supports the amendment proposed by the Italian Republic. We believe that the migration issue should remain on the agenda and that national parliaments ought to encourage the European Commission to actively seek appropriate solutions. So as I said, Slovenia, if it does come to vote, Slovenia will support the amendment. Thank you.
Thank you very much. Then we go to Mr. Tancredi from Italy. Mr. Tancredi, you ask the floor.
Thank you, Chairman. I'd like to thank all colleagues who've expressed support for this amendment being included in the conclusions. For the sake of the dignity of our work, I think we should adopt this amendment. We should today, COSAC's contribution today has some very important points in it. This is a very high-profile document, and we've had some very interesting discussions. But if we don't include immigration in this contribution, then there is nothing that really directly interests European citizens. The problem of migration has an extremely strong impact on everyone. So I think that we should vote on this amendment, and I would appeal to all delegations to vote in favor. And even on the last part of the text, certainly we can take on board some of the suggestions that were made. We would say welcome to the indications and the efforts being made by the committee to reform, or by the Commission to reform European reception practices, and also efforts being made to improve the Dublin Agreement. We don't have any detailed preconditions here. We've provided our orientation, and we are open to these policy changes. So we firmly maintain the submission of this amendment, even though, as we've said, we accept the suggestions made by Greece and Mr. Bizet.
All right. Then we go to Mr. Kriegbaum from Germany. Mr. Kriegbaum.
Thank you very much, Chairman. Yes, I think we've had a very good discussion, a very good debate. And Italy's amendment is certainly serious, and so we would have to vote on it. If we want to discuss procedural matters, then we would have to proceed to a vote. And it's only if it doesn't go ahead, then Lord Boswell's amended proposal could be put forward and voted on in due course. Could I just point out, in response to what Greece was saying, he wanted to have a mention of Asia. I think Italy's proposal says, in English, with particular reference to the African countries, end of quote. So it doesn't say only Africa, it's saying in particular Africa. So I think that does include other parts of the world. So Asia, for example, is included implicitly. I therefore think the Italian proposal is very good. Many delegations have spoken out in favor of it this afternoon, or is it this evening? I think the time has now come for us to vote on it. Thank you.
Thank you very much, Ms. Kriegbaum. I want to give one person the word for the floor, and it's Mr. Herzig from Hungary, and that is the final one. Mr. Herzig.
Thank you, Mr. Chairman. Just, I would like to say that is it possible to support Lord Boswell's amendments, which is a real compromise one. We have to vote on it.
All right. Thank you very much for all your contributions and all your saying about this important issue where we also, every member state is confronted, and also every member state has a responsibility on this specific issue. We had a proposal, a compromise, I believe, from the oral things that has been said, and I also heard the Italian delegation, because it's an Italian amendment, what they accepted, for example, from France and also from Greece, the oral views. And can I let them see the amendment? And I believe that's... Yes, that's then a compromise proposal for the presidency. Yes, maybe Tuur Elsinga, you want to add something about this specific?
Well, very shortly, as we suggested first, we were, for the reasons also repeated by our Slovak counterpart in the Troika, we suggested not to accept it. But we have listened very carefully. There is a big group of countries that really wants to have this amendment in the report, and we have also heard a couple of obstacles to the amendment of the Italians, and we have tried to take care as much as possible with the obstacles that were specifically mentioned. So we hope that this is a good compromise also for the Italians. I see that they can support it. So let's see if we can find a consensus here.
See if there is consensus on this proposal, and I see the Italians are in favor. Yes? No. Mr. Romano, may I give you the floor?
Grazie.
Thank you. Yes, we agree with what you've just proposed.
Also, I'm sorry, the microphone was not on. Is there consensus on this proposal, on this amendment, to add it on the contributions on this presidency? Yes. Thank you very much. No?
Ms. Hübner.
Ms. Hübner from the European Parliament, may I give you the floor?
I'm just extremely sorry, but during the same meeting, within 1 hour, we have different rules for the procedures. There is a request from European Parliament on having oral amendment to the amendment which was presented in written form, and there is a refusal because you cannot have an oral amendment to something which was not provided in written form. Now we are very softly reaching out to this possibility of having oral amendment, so I would like just to say that I don't understand. Thank you.
All right. Yes, we came back to this debate and the discussion on 6.4. I don't do it as a chair because we're voting on both amendments. And there was, of course, there was an oral suggestion, but I see also the amendment from Poland, from Hungary and Poland, and they don't accept that oral issue. That's the reason. And my task as a chair is to see if there's consensus. And I hope to the debate that we have now on the migration issue that we have a consensus now on this amendment. And I hope so that the European Parliament is also consensus on that amendment. Yes? Is there consensus? Yes? All right. Thank you very much. No? Yeah. If there is one remark from Hungary, I'm sorry, colleagues from Hungary, Mr. Herzig.
Yes, Mr. Chairman, I do not want to make any trouble, but I would like to come back just briefly, that's for a mention, paragraph 6.4, just to memorize what's happened. During our debate, I mentioned that if the COSAC doesn't accept the Polish-Hungarian amendment, that's happened. Mr. Chairman, I agree. I suggested to add a sentence which is very neutral, I think. At the same time, COSAC acknowledges diverse views regarding the establishment of new mechanism. That's all.
Very much, Mr. Ertug, but we have voted about the two amendments, and yes, the procedures then that we must accept the votings, and we stand on the proposal from the presidency. I'm so sorry. Okay. Then we reach the consensus on the contribution. Many thanks for your cooperation. I'm looking forward to have a smooth session tomorrow in which we can accept the outcomes in this meeting, hopefully unanimously. For now, I would like to invite you all, on behalf of the President of the Senate and the Speaker of the House, to tonight's dinner. It will be a nice dinner, just as you head of the delegations. I hope that you stimulate also your delegations to come with us with the dinner, and the business leaves at 7 p.m. from the hotels. And just outside the inner court is also a place, it's called the Haringkar, and our staff will show you the way. I wish you all pleasant evening, and thank you again for your kind attention. Thank you very much.